appeal in the matter of Hopcraft and Close Brothers Ltd and Wrench and Firstrand Bank Limited and Johnson and Birss.
Well, good morning, everybody. Before we begin, can I express the collective thanks of the members of the court to all the staff for agreeing that they would sit early. We couldn't do it without you, and we're very appreciative of that. So thank you very much for sitting at these unusual hours to accommodate my lord. And thank you also to all counsel and all their legal teams for coming here at 9:30 and for being so cooperative. We all appreciate that very much indeed. Should you wish to have a short break mid-morning, I know there's going to be possibly some swapping of personnel, but if you find a convenient moment and tell me, then of course we'll have a 5-minute or 10-minute break. I think we're still well on track to finish tomorrow, so hopefully that will be no problem.
Your Ladyship will see that my learned friends have changed positions, but that's only because Mr. Hardwick likes to get very close to his source of power. I'd like to take him very far away from his source of power, see what happens, but that's where he is, and that's why he's there.
Okay.
Can I start by just seeking to answer the question as to whether we are going to contend before this court that accessory liability is not required in a half-secret case. With thanks for a thought that hadn't really crossed our minds. Nevertheless, we're not going to do that before this court because the Court of Appeal case of Firstrand seems to us to be a bar at this level to making such a submission. And so we would wish instead, please, to reserve our position for arguing otherwise in another court should that occasion arise.
So you're not going to contend that accessory liability is unnecessary in a half-secret case, but you reserve your position?
My lady, yes. And with gratitude to the court for making us think further about the logical consequences. My lady, in relation to the next issue which was raised, which is accessory liability for a duty other than a fiduciary duty, we've sent, but I believe sent literally moments ago, but now sent to your clerks, a small supplemental electronic bundle of 2 cases and 1 selection from a textbook. So I wonder if the court can kindly see if that has now been forwarded by your learned clerks to yourselves, or I can come back to that.
Well, I think you're going to have to come back to it because my clerk has public transport difficulties this morning and another clerk has very kindly stepped in to look after me. I have no means of finding out at this stage.
Yes.
My lords may be able to find out whether it's reached them. But
well, my clerk was standing there about 2 minutes ago, so he won't have...
No, he won't have got it yet.
The best one in the world, he hasn't sent it to me yet.
No. I think we can park that for later, Mr. Ware.
I'm very grateful. I will try, we're going to get some hard copies brought in, and I'll try to deal with that so that my friends, given there'll be also the overnight and lunch, at least have heard what I have to say, and then have a proper opportunity to respond without us all getting out of order, and then having replies to replies and so forth.
All right.
Can I then go back to the close questioning of my Lord Justice Birss in relation to the Deputy District Judge's judgment? And can I pick it up by going back to the judgment, please, and start with paragraph 21. It's core bundle, tab 14, page 205. 205, paragraph 21, contains in the sort of bullet point orbit lettered form, which you see from page 204, the learned district judge's assessment of what the claimant said in oral evidence. So this is page 205, my lady, of the core bundle. It's tab 14, I think.
205.
205. But strictly speaking, it starts at 204 to orientate
Yes.
yourself, para 21. However, the claimant did say specifically in his oral evidence, and then if you go over to page 205 and down to S to V inclusive,
I agree to the yes.
yes, yes, my lady, I agree to the interest without knowing about commission. The commission meant I paid more interest. I'm angry because I paid more for something I wasn't aware of. I believe I could have paid less if there was no commission. And that actually comes alive. I'm not going to take you to it now, but it comes alive should you wish to see the cross-examination in the Johnson bundle, tab 19, pages 81 to 85. And that was the part of the cross-examination I had in my mind, and I said it was someone, and it was Mr. Johnson.
Yes.
And you'll see how you've got the barrister on the one hand saying, well, you know, you're paying the same amount anyway, and you know what it is, see the APR figure. And you've got Mr. Johnson continuously replying, if you like, in an equal and opposite direction, because he's actually addressing a slightly different point, which is what I'm coming to, that he's very cross, that he paid for something when he then discovers that quite a lot of that cost of his interest he had to pay was actually just for the commission for the broker.
Yeah.
And so then if we go back to the learned judge's judgment at paragraph 34, page 207, so it's 33 to 34. So para 33, what you've then got is the Deputy District Judge quoting from the witness statement, but it's all part of the same point. It's what I called a cross point. He's cross about this, and you see it in the cross-examination. He's cross that essentially he's paid not just for the capital cost, because the capital cost was the forecourt price. It's not the forecourt price that he's complaining about. It's the interest that he's paying, and the interest he's paying, he's discovered, is actually 62.7% commission, and that's why he says, if you told me that you require me, or I was being required to pay interest, of which 62.7% was just to go back to the broker, I wouldn't have been happy and I'd have walked away. And our submission is that the learned deputy district judge doesn't really understand that point that's being made. And so he is addressing something different. Because the district judge says, I find the claimant said this because he mistakenly believed that commission had a bearing on the cost of agreement. It didn't, because it was based on the amount of the capital, not the interest. Now, it's right that it was based upon the amount of the capital, but it in no way diminishes the force of the upset that the customer is experiencing, and that's what I was trying to get across, but unsuccessfully yesterday. And for the record, when it says the commission would have been the same if the interest rate was 13%, that is not accurate. And if we go to the Johnson file, tab 3, pages 14 to 15, this was the lender-broker contracts. I'm in Johnson file, tab 3, pages 14 to 15. Now, it's not the most straightforward document. My learned junior actually cross-examined the representative from First Bank in relation to this, and I can then thereby explain what goes on with this contract. On page 14, it says recommended retail price 13%, minimum retail price 8%. The language is bizarre because it's just the interest which is being charged, but that's how it's described. And this is what rate of interest can be selected between 8 and 13%. And if you go over the page, at the top where it says dealer commission, hire purchase and HP plus PCP, and then it says RSI, and you see from the next box down that RSI is revenue share of advance. And again, this is frankly bespoke at best or bizarre language, but the effect of it is that if the broker or if the percentage selected is up to 13%, then the broker gets 80%. Oh no, maximum commission, 80% of the difference between the 8% and the 13%.
Okay, just say that again slowly. So if the percentage is 13%,
then there's
the broker gets
there's a share. It's a revenue share of
a
advance.
revenue share.
And the share that he gets is, and I hope
80%
is
of the difference.
80% of the additional 5%. See the RSI figure at the top.
Yeah, got that.
So actually, the commission would have been the commission that there was in this case plus 80% of 5% of the cost of the car, as it happens in this case.
Right.
I'm not really following this document. I do understand the point you've just made.
Yes, well, it's a document, as I say, required cross-examination in order to elucidate, because actually it was exactly the same issue I had last night when it was being explained to me.
So what you're saying is that actually the Deputy District Judge has made an error in fact.
He's made an error in fact when he says if it was 13%, because actually if it was 13%, the commission would have gone up in line with this agreement.
Yeah.
But the general point that the commission was set by reference to the price, if it's 8%, is right. Our submission is all of that is what I would describe as a private matter in a contract between the broker and the lender. And that may be factually accurate at the 8% level.
Mr. Johnson's point's very simple, isn't it? If they hadn't had to pay £1,600 to the agent, they would have been able to give me a better rate and made themselves more profit.
It's exactly the point, my lord. It's a matter of what I was going to describe as common sense. Yes, ma'am.
I completely understand my lord's common sense, if I may say so. What I interpret your submission to be is that, that's fine, is that it's not right to say that the commission is entirely based on the capital cost.
If the commission's
at
at 8%,
what you're saying,
if it's 8%, at 8% it is, there's no RSI. The RSI kicks in if the percentage, the interest rate is above 8%.
Right. And what was the interest rate?
8%. It's why I've been careful when I've said, I'm just referencing here, that discrete point is when the judge said the commission would have been the same if the interest rate was 13%.
The answer is no.
The answer is no, it wouldn't.
The answer is no. If it had been 13%, there'd have been an additional commission, but there wasn't the additional commission because it was 8%.
Yes.
I hope that's clear.
No, I understand that. I mean, I do understand, if I may say so, the common sense point.
Yes,
I still don't quite understand how this all fits together. So anyway, fair enough.
Well, how it fits together, my lord, is that the customer has made a complaint. The learned district judge has said, you're wrong to make this complaint. And
because
he's gone.
you pay the same amount, although and he doesn't actually see the common sense point that my lord has put.
Exactly the point.
Yeah.
In other words, one only has to, as with so much, if you make the experience personal, it tends to come alive.
Yes.
If I've got go to a bank and get a mortgage, and then next thing I know, the interest that I'm busily having to work hard to pay, I discover that 63% of that went to the person who rolled up at my door once and told me I should get this. I'd be at liberty to think, I bet I could have got something cheaper.
Mm.
And the fact that they've got a contract that says, no, it's minimum 8%, just tells you how much profit they're making. Too much. And that's our complaint, because what the claimant was doing is exactly that which Lord Sumption was identifying as key in Plevin. So it's not what's the deal that's going on between the broker and the PPI provider. It's not what sort of special deal have they got that no one sees until you litigate and get disclosure of a document like this that even then is pretty difficult to understand without cross-examination. The point is a much more straightforward one. And using the language of Plevin, the customer was denied the opportunity to make a properly informed judgment about the value of the loan to him. And I made a submission yesterday that we had to appeal because of the thrust of His Honour Judge Jarman's order, but I should also just take you to his judgment, please. It's Core Bundle, tab 9, page 153. And it's paragraph 29. And if you kindly read paragraph 29, the effect of which is that he considered Plevin not to be relevant. So it's the last point. In my judgment, that was an appropriate course to take, namely considering Plevin was not engaged at all, on the remarkable basis that it can be distinguished on its facts. Every case is different on its facts. I don't think Lord Sumption was limiting himself to the world of PPR. That completes, my lady, my submissions in relation to what I called a Plevin part of the unfair relationship case. And that's the freestanding case that is unanswerable and therefore merits in our respectful submission confirmation from the Court of Appeal without a remission. There's nothing that would happen on remission will help the lender in these circumstances. We make short additional points in our written skeleton argument, which I'm just going to literally touch upon. And they're to the effect that if the court finds that the broker was in breach of its disinterested or fiduciary duty, then the relationship between the borrower and the lender was unfair. Now, obviously, if the court then goes on to say there's accessory liability on the part of the lender, it stands to reason, you might say we don't need it because we'll have won accessory liability, but it stands to reason that the relationship's unfair because you've just made a finding of accessory liability on the part of the lender. But if you don't make a finding on accessory liability, there are two routes through. The first is indirect, which is via Section 56 of the Consumer Credit Act, which attributes responsibility for the broker's non-disclosure to the lender. And it was common ground that this applied in this context before the district judge. I'll just give you the reference. It's Core Bundle, tab 14, page 203, at paragraph 9.
Core Bundle tab?
Tab 14,
yes.
Page 203 at paragraph 9.
Thank you.
And the other route through is because Firstrand's payment to the broker in and of itself deprive the claimant of the impartial and disinterested performance by the broker of its duties, that suffices to render the relationship between lender and borrower unfair within the terms of Section 140A. And for that, just take you to one authority. This authority snuck its way into the Core Bundle, where this is, I think, the only real basis on which it's being referred to. It's a case called Nelms in the Court of Appeal, and it's Core Bundle tab 7, and it's page 112. But again, strictly speaking, it starts at page 111. This is a case involving a businessman rather than a naive member of the public who had a portfolio of 25 buy-to-let properties, and he entered into some sort of enormous remortgage of all the properties, which went horribly wrong. And he had a broker, and if you pick it up at page 111, and you can go down to paragraph 34, in respect of the procuration fee, however, the position is different. Mr. Blair/AWC was acting as agent, that's his broker, for Mr. Nelms in his dealings with NR. Mr. Nelms was entitled to his undivided loyalty. And the payment of the procuration fee by NR to Mr. Nelms, in other words, a commission, called here a procuration fee, by the lender to the claimant's broker or agent, was kept secret from him, and its acceptance by the broker, who was charging 0.75 of the amount advanced, was a breach of the duty owed by him to Mr. Nelms. And then if you go over the page, paragraph 35, it's paragraph 35, I'm just going to invite you to read, it's a short paragraph please, shortish. So as we understand that passage, it's a sort of direct route rather than a vicarious route. It's saying if you choose to make that payment, you don't have to establish accessory liability. If you, the lender, choose to make a procuration fee, or I would say commission, payment to the broker, you are, by that route, going to render your relationship with the borrower unfair.
I don't know, Mr. Weir, whether you've had a chance to think about this, but it occurred to me that if, by virtue of the Consumer Credit Act, or indeed subsequent legislation, Parliament has seen fit to deal with elements of perceived unfairness in the bargaining relationship in circumstances such as these, it might be said that there is no room for any equitable principle to fill the lacuna in circumstances that Parliament hasn't catered for, or for duplication of Parliament's rule by an equitable stopgap.
Well, Lady, that would be a very brave submission to make, and quite unfounded in the circumstances. If we go back to secret against fully secret, if we've got secret, you're going to hear very interesting, they're not going to be very interesting submissions in relation to how the law should be reshaped. But just as I understand the law at the moment, we have something called a tort of bribery. Oh, yes. Which subject to all that my own friends going to seek to achieve here or elsewhere is a good tort. It exists. That's not been broken up by the in about 2006 the introduction of Section 140A of the Consumer Credit Act. That would be a brave submission. We have equitable remedies that arise in a fully secret case. I've shown you the passages in Wood. I can't understand how they are deemed to have somehow been knocked out by Parliament. There's wonderful case law. There's a case, Lord Sumption, called Latchow, which makes clear that when Parliament legislates, it does against a common law background. It can be taken, A, to understand the common law, and B, not to seek to interfere with any of those common law rights, more than the extent that's absolutely necessary. And it would be expected, if it was going to do something brave and interesting, it should be express. And there's plenty of authority in relation to that, including a case recently in the Supreme Court involved in on just that sort of an issue.
I'm not sure that, Mr. Weir, I'm not sure that it's the tort of bribery that we're looking at. It's this halfway house of half secret.
Yes, I was starting.
My lady, it is. To what extent should we be developing the law in relation to half secret, which seems to be a modern invention, really, going back to Erstanger, and wrestling with concepts such as accessory liability for breach of a duty, the legal nature of which which is quite unclear. If it's not a fiduciary duty, what is it? We know it's a duty to give disinterested advice, but what jurisprudentially is it?
My Lord, yes, I'm going to come back to that because that's the bit well, I will come back to that, but I started with a talk to bribery because that sounded like a solid piece of rock.
Yes, well, it is, I think, but we're more concerned with the shadows between the rocks here.
My Lord, yes. If I move into the shadowland, which I don't actually see as shadowland, I see as again rock solid equitable principles in play. The same principle applies. That there are a number of judgments, including that Lord Sumption judgment, that make this point, that you would have to read the statute very carefully to understand how it sought to actually divest claimants of rights they otherwise enjoyed, and we are a country mile from that scenario. It's just not how statute works. Secondly, for the avoidance of any doubt, the unfair relationship, for instance, based upon the size of the commission is not of general application if the commission is very small.
Yes, and you've got your clients are only, I think it's only one of your clients who's actually raising the point.
Well, I think it was raised below in one of the other cases, but not succeeded and not pursued on appeal.
Yeah.
But it isn't of general. It's a general application, as in Section 148 exists and sets that the relationship must not be unfair between lender and borrower. But it doesn't just follow as night follows day on a commission payment.
Well, if it's unfair by reason of the fact that the commission is secret, then it doesn't matter what the amount of the commission is, and therefore it would apply across the board.
Precisely, my lady. In other words, it's aiming at a different target. When we go back to what we saw in Plevin, it was the description that Lord Sumption gave. I think it's maybe para 17 or thereabouts, 18, in which he says, a sufficiently extreme inequality of knowledge and understanding is a classic source of unfairness. Yeah. It's a question of degree.
Yeah.
And that's the question of degree issue. So they are related or linked, if I can put it that way, in that the underlying, we would say, legal wrong that is being committed is the same. So, if you like, the same essential facts underlie multiple claims. That is not unusual. It's a bit like being able to sue in tort and contract. Yes. If as an employee, tort contract, and no doubt, statutory rights which are invested in an employee. But one doesn't say you've got a very sophisticated system in relation to. That is different because that's focusing on unfair dismissal and so forth, and there is case law as to divide lines between that and common law rights. But the ladyship sees the point. They really are different. They overlap. Section 148 is of general application to that relationship, and it's put in such broad terms, as you saw from Section 148, that's Parliament saying you almost look at all the circumstances, and it's difficult to think of circumstances which you don't look at in order to make this judgment call as to whether the relationship's unfair. If the force of the observation was right, it would essentially mean that in the overarching relationship between borrower and lender, it's now been overtaken by Section 148, and that is only has to be stated to be seen. It can't be right. There are a host of specific rights which are enjoyed by a borrower. There could be a claim in negligent misstatement on a given fact. There could be a claim for breach of contract on given facts. There could be implied terms into the breach of contract. There could be all sorts of things that go on. It could be, again, that's the sort of a bit of a tester like the question from a Lord Justice Birss in terms of what rights do you have in these interesting situations, which I think reduced to simply rights against someone because I've got better rights as a hirer of that vehicle at that stage than you as, by that stage, the garage is a third party. Interfering with my rights to hire, which is superior to the third party's right. It might be someone else who's walked onto the forecourt and tried to stop me taking the car. I think is the answer. Well, lady, I am now in a position to make submissions. I'm very keen to just make them to complete my submissions if possible, so that my own friends.
Well, we now have the bundles.
Exactly. That's why I'm saying that I'm now in that position. So can I, again, with gratitude for the question being put, because again, it's not one that we'd actually sort of bottomed out in that sense properly, Can I make the following submission? The submission is that there can be accessory liability attaching to the disinterested duty. There is no case that says this directly. Attaching to the disinterested duty that we're aware of, which is not surprising because Wood was only recently decided. Wood is a fully secret case in which you do not need accessory liability, and our case involves what we've been calling the logical extension of Wood into half-secret cases, which until now have been seen as cases requiring fiduciary duties. So the issue just hasn't arisen. And we rely on a number of points. First, and this is a partial response to my Lord Justice Edis' earlier observation, our case, we're quite content with a case that acknowledges what Lord Justice Richards said in Wood, that the disinterested duty can be understood anyway. It's my language, a species of fiduciary duty or a subset, but I'll use that language and take you to the quote, as a species or subset of fiduciary duty. It's this distilled fiduciary duty, not with a panoply of obligations, but with a specific obligation, and it's got an arrowhead, and the arrowhead becomes disinterested, the duty to give disinterested advice. Now, the relevant paragraph, I did take your ladyship and your lordships to it yesterday, but I then said I wanted to find it again and couldn't find it, and I found it again now. It's Core Authorities Bundle, tab 11, page 271, paragraph 102. Going to take you to that, if I may. So it's page 271. This is why, on this basis, we're not, we say, in Shadowlands. We can be understood to be in a subset of fiduciary duty, because what Lord Justice Richards says is, my conclusion from this over-lengthy citation of authority is that in cases such as the present, where an agent providing advice, information, or recommendations has received or been offered a bribe or secret commission, the question that the court should ask and focus on is, did the agent owe a duty to be impartial and to give disinterested advice, information, or recommendations? So just pausing there, he's absolutely into his disinterested advice. If the answer is yes, the remedies discussed above are available. Courts have, principally in recent years, characterised this as a fiduciary duty of loyalty. While this may be accurate, is what I'm emphasising. He then says, it doesn't mean that you need to involve yourself in complex analyses of the nature of a fiduciary relationship. So, I mean, yeah, that's a matter of interpretation, but my understanding of that is that essentially Lord Justice Richards is recognising, if you go back to the paragraph that I referenced before at page 267, para 86, we're in the quote there, then for correcting me, it's the Court of Appeal, but it's the Court of Appeal of Lord Briggs and Lord Justice Hamblin, as he then was, and see how they have combined two copies, my lady, and see how they've combined in that sentence at H. The principal thinks he's getting the loyal and disinterested advice of his fiduciary.
Yes.
And I think what Lord Justice Richards is recognising is that he's traversed cases that reference disinterested duty. I took you to those. Then around para 71, I think 73, he said, let me look at the cases that reference it via fiduciary duty. This UBS, which I took you to, was a classic because it was disinterested fiduciary. And Lord Justice Richards is saying, look, I don't mind. It may well be right that it's fiduciary, but what he was terribly keen to avoid was the making the use of the word fiduciary essentially redundant or without value, because he's so distilled in his analysis. And I'm just looking for the paragraph on that. It's paragraph 46 at page 260. Risk inherent in requiring a fiduciary relationship as a precondition for remedies in respect of bribes or secret commissions is either that civil remedies which should be available will be denied because there isn't a fiduciary relationship, or that the term fiduciary relationship applied so widely as virtually to deprive it of content beyond the simple proposition a person under a duty to another mustn't accept or be offered an inducement to influence them in the performance of that duty. And that's why he has preferred to ask the question, is there a disinterested duty, as we call it, a duty to give disinterested advice, recommendations or information. But jurisprudentially, it can be understood as a subset of fiduciary duty. That's our first point or submission. Secondly, accessory liability is already understood to attach to the other core equitable duties relating to breach of trust and breach of confidence. And there's a case called Thomas and Pierce, which we've got in our little bundle of accessory liability cases, and we've given it external pagination. If you kindly go to page 78. Lord Justice Buxton in that case approves a passage in Mr. Justice Toulson's, as he then was, book on confidentiality, which we've sidebarred, which concludes, this principle is derived from the doctrine that it is equitable fraud in a third party knowingly to assist in a breach of trust, confidence or contract by another. And he then applies it in that case in relation to a breach of confidence case. Thirdly, an academic, Paul Davies, has opined in his textbook, Accessory Liability, that accessory liability attaches to any breach of an equitable duty. And here, if you can stay in the same bundle, please, and go to page 68. We've not sidebarred this, but I think it's the last sentence. It suggested that in Tan, Lord Nichols sought to move away from the view that the breach had to relate to property, but didn't intend to demand the breach of fiduciary duty in the strict sense. Any breach of an equitable duty would appear to suffice. And at 74, under his heading Conclusions, first sentence, accessory liability can be parasitic upon any equitable wrong. The most important wrongs are breach of trust, breach of fiduciary duty and breach of confidence. Fourthly, this all makes sense because so far as I can tell, the approach taken by the courts is that logically accessory liability should apply to any wrong, legal or equitable. Otherwise, a person dishonestly procuring a legal or equitable wrong would avoid any liability. And in this context, I understand procuring to be synonymous with, or at least a subset of, accessory liability. And Lord Justice Tuckey certainly transferred from accessory liability in Herstanger at paragraph 34 to procuring at paragraph 45. And I understand them to be the same, and I'm going to take you to Lord Leggett in a moment, who I understand to also take that view. So that makes sense, because otherwise there'd be a lacuna of liability for someone who's engaged in knowing, or modern language dishonest, but from logic cross it's knowing, assistance or procuring of a legal wrong by another. So as to the approach more generally, can I now, again with thanks, Lord Justice Birss, go to the lifestyle equities case, can I start at page 34? And at page 34, under the heading Accessory Liability and Equity, I think what we can see in that section and following is the mind of Lord Legate working on the basis. We know there's accessory liability in equity, see paras 96 to 98. And he's certainly comfortable with the idea that breach of trust or fiduciary duty gives rise to accessory liability. Then see paragraph 99 in the heading inducing a breach of contract. He recognises that there is accessory liability for breach of contract. And in essence, it flows from that he proceeds to analyse how there is also accessory liability for what he describes as procuring a tort, which he takes by reference to the case law, starting at paragraph 102. But he says it starts, liability for procuring a breach of contract does more than provide an analogy with liability for procuring another person to commit a tort. Both forms of liability rest on the same underlying principle. This principle was stated in Lumley. It's clear that the procurement of the violation of a right is a cause of action in all instances where a violation is an actionable wrong. He who procures the wrong is a joint wrongdoer and may be sued either alone or jointly with the agent in appropriate action for the wrong complained of. And he's already identified that wrongs include equitable wrongs, see 96 to 98, and it's part of his journey. Which leads to his conclusion at paragraph 107. When in the middle he says that analysis is just as applicable whether the action were wrong, which the defendant procured as a breach of contract or a tort. What is required is that the defendant acted in a way that was intended to cause another party, the primary wrongdoer, to do an act which the defendant knew was a wrongful act, turning a blind eye being sufficient for this purpose. And then para 108 is the paragraph that my Lord Justice Birss essentially referred us to yesterday, which sets out, again, so that for the avoidance of any doubt, that ignorance of the law is no excuse, etc. And if you like, brings alive the test. And then finally, in relation to that, if you see at paragraph 135, which is at page 45, under the heading Conclusion on Accessory Liability, Lord Legate observes, to summarise, there is a general principle of the common law that a person who knowingly procures another person to commit an actionable wrong will be jointly liable with that other person for the wrong committed. And I would simply say he there is addressing the issue of a discrete issue of procuring a tort. So it's unsurprising he uses the language of an actionable wrong as a general principle of the common law. But he's earlier taken a journey through equitable wrongs, and there is no reason in logic to distinguish between the two, so that Paul Davies is respectfully in this context right to say it applies to all equitable wrongs. That's my logical point. I mean, why would it not? Why would you have a lacuna? And again, just finishing with Paul Davies at page 58 of this bundle, at the beginning of his textbook on accessory liability, at the bottom where his sidebar, the heading 1, what is accessory liability? For accessory liability to arise, a primary wrong must first be established. This may be a breach of an equitable obligation, breach of contract, or a tort. And that can include, as I understand it, statutory torts. So, my lady, those are the reasons why we say that even if, in a world of disinterested duty, either subspecies of fiduciary duty or freestanding, this court should have no difficulty in establishing that there is a principle called accessory liability which applies, because it would be only fair that it does, and it would be grossly unfair if it were not to. Well, Eddie, unless I can assist further, those are the appellant submissions.
Thank you very much. Right, who's going next?
My lady, I am. Can I just take one moment to shift my things?
Well, do you want us to rise for a minute while you sort out the logistics, or?
I'll be ready in literally about 30 seconds.
All right.
My lady, my lords, good morning. I appear with Mr. Popplewell on behalf of Firstrand Bank Limited in order to resist these second appeals of both Mr. Johnson and Mr. Wrench. I hope you will have my skeleton. I think it's the second tab of the core bundle, and in a slightly different way to that which Mr. Weir has done. I do propose to anchor these submissions in that skeleton. To save time when there are points that I can flick through. Obviously, I'll be responding to Mr. Weir's points as I go along, but it would assist.
Do you want us to have your skeleton argument to hand?
I think it would help, and it may save time.
Yes.
And certainly all the references are there, and I'll be following the flow and the order that is set out in that skeleton. So I think it's core bundle, tab 2, page 49.
Yeah. Yes.
Now, what we identified in the second paragraph of that, as you'll see, were what we took to be essentially 4 issues arising out of the skeleton argument of the appellants. You've seen them and heard them slightly recast by Mr. Weir, but not in a substantive way. We identified the first issue for us as the secrecy issue, whether Wrench was a fully secret. Mr. Weir identifies that as issue 4, but I am going to deal with that first. We identified the second issue as whether the disinterested duty suffices in a halfway house case. That was Mr. Weir's issue 1B. Our issue 3 then comes onto the question as to whether a relevant duty was owed, whether disinterested or fiduciary. And that really covers quite a lot of Mr. Weir's ground, issues 2, 3, and 5, engaging the accessory point as well. And I'll deal with all of that in that context. And then what I'd identified as issue 4 is the unfair relationship point. That's Mr.
Yes.
Weir's issue 6. And I'm delighted to say that Mr. Popplewell, my learner junior, will be dealing with that 4th issue. And very briefly, the court will have read our position in summary, that we say it's not Wrench was not a secret commission case. The clauses in the respective credit agreements disclose the fact that the commission may be paid. That's enough to negate secrecy and to qualify as a halfway house case in accordance with Herstanger. On issue 2, disinterested duty, we say no, that's not sufficient in a halfway house. There is well-established Court of Appeal authority, and of course, in particular, Herstanger, that no, in a halfway house case, it is necessary to establish that fiduciary duties are owed. On issue 3, as to whether the relevant duty is owed, we say no, the brokers didn't owe either the disinterested duty or the fiduciary duties. They were acting in their own interests, arranging finance to facilitate their sale of the motor vehicles. And issue 4, in relation to the unfair relationship, we do say, and for reasons Mr. Popplewell will develop, that the court shouldn't engage with this allegation in circumstances where the judge at first instance, District Judge Sarnikov, says it wasn't unfair, and the judge on appeal remitted it for particular consideration of particular questions including, in particular, a factual question as to whether what was called the dealer disclosure document had disclosed commission. So that, in a nutshell, is what I will be covering. What I should also clarify at the outset is our position in relation to the Hopcraft appeal and the arguments of Close Brothers. Now, we're obviously not involved in that appeal. We represent, and we only represent Firstrand Bank in the Johnson and Wrench appeals. Close Brothers, of course, are represented by Mr. Wilson and Mr. Day. What you will have seen is that prior to finalising our skeleton for the purpose of these appeals, we did see the Close Brothers skeleton. And we said in our skeleton, we support the points of principle. But we also pointed out that in circumstances where our position is that Wrench and Johnson are both half-secret cases, we do not need to demonstrate any error in the reasoning in Wood. And to be absolutely clear, for the purposes of these appeals, we are content to proceed on the basis of the law as set out in Wood. You will hear no criticism from us of the reasoning of Lord Justice David Richards in Wood. Indeed, we will be seeking to apply it. And of course, we haven't filed a respondent's notice. We have no permission to rely on any additional ground in relation to this. And our position is we just don't need to. Johnson is a half-secret case. That's common ground. Wrench, as found by His Honour Judge Worcester, was also half-secret, and as identified in Herstanger and a raft of Court of Appeal authorities, there isn't a need. There is a need for a fiduciary relationship in half-secret cases, and I'll be coming very carefully to that. What I also would like to say in outset is that in these three conjoined appeals, it is the bank alone amongst the parties that I respectfully submit takes a position that is neither controversial nor ambitious, and which simply invites this court to apply well-established legal principles at Court of Appeal level. Now, Close Brothers invites you with conspicuous learning but equal ambition to conclude that the reasoning in Wood was wrong. The appellants perform a significant U-turn on their stated positions below, as we've indicated in our skeleton. Below, they had indicated, their junior counsel, that in half-secret cases, a fiduciary relationship is a necessary precondition. And that was a position adopted well after Wood, in 2022, 2023. In these appeals, the appellants say, no, we got that wrong. In fact, a fiduciary relationship is not a precondition to the payer's liability in half-secret cases. Although, and I'll be taking the court carefully for this, Lord Justice David Richards clearly does not state anywhere in his analysis that the disinterested duty was sufficient in half-secret cases. The position of the bank, I respectfully submit, is modest and non-ambitious and seeks to apply well-established principle. First, in relation to the secrecy issue, that if you apply the reasoning of Lord Justice Tuckey in Herstanger, that Wrench is a half-secret case. Because the disclosure of the fact of the commission in the bank's terms and conditions, that's enough to negate secrecy. Obviously not fully informed consent, but enough to negate secrecy. On issue 2, it is necessary to identify fiduciary duties in half-secret cases, applying Herstanger and looking at passages in Wood. And on issue 3, the duties, applying Mothew and the identification of the core fiduciary duty of undivided or single-minded loyalty. His Honour Judge Worcester, para 38 of his judgment, His Honour Judge Jarman in Johnson, para 19, they were absolutely right to conclude that the respective motor dealers, whose primary interest was to sell the cars, couldn't and didn't offer single-minded loyalty to the customer when dealing with finance. That then, very briefly, is the outline, and I propose to go straight to our issue 1, which is picking up in our skeleton of paragraph 18, whether the commission in Wrench was a fully secret. And this issue arises out of ground 1 of the Wrench appeal only. I think I probably should show the court the ground of appeal on this, just to anchor it carefully there, because we haven't seen that yet. It's at page 257 of the core bundle. Just to make sure I've got that. It's tab 18, and it is indeed page 257. If the court has that, so core bundle, tab 18, page 257. We're in the wrench grounds of appeal. Ground 1, judge was wrong to find the commission were only half secret, ought to have found they were fully secret. In particular, A, the judge erred in his approach to the burden of proof. Defendant to establish the written commissions had the effect of negating secrecy. B, the judge erred in that he proceeded on the basis it wasn't necessary for the commission statements to be drawn to the claimant's attention in order for the statements to have the effect of negating secrecy. So those are the two grounds that are relied upon. Can I also take the court to the way it was pleaded, just to understand the allegation faced by the bank in this case? And this is at core bundle paragraph 28. And if I could ask the court to look, please, at page 344. Wanting to look at 344, so paragraph 23 of, and this is the amended particulars of claim dated the 24th of October 2022 in rent. So if you have just above the circumstances of sale, about halfway down the page, paragraph 23.
I'm lost, Mr.
I'm so sorry, page 344 core bundle.
Core bundle.
I'm so sorry if I...
344
core bundle.
Okay, on there.
Para 23, halfway down the page. The credit broker was in a position whereby it had a conflict of interest which the credit broker and defender omitted to disclose but which should have been disclosed. 24, the payment of commission without the informed consent of the claimant amounted to a bribe and put both the credit broker and the defendant in breach of the fair dealing rule. So that's the allegation in wrench of a bribery claim, and if I could show the court the equivalent allegation in the wrench claim, just to see how it's also put there, and you'll find that at page 225 of the core bundle. 225 of the core bundle. We're now in the Johnson particulars of claim, 18 November 2021. At the bottom of page 225, where the allegation is picking up a para 32, the claimant will say that the existence of the amount of commission had not been expressly communicated to them and they weren't aware a commission would be paid. Over the page 33, a secret commission payment has therefore been made which amounts to a bribe as a matter of civil law. 34, the payment of this secret commission has tainted the finance agreement with fraud. So very similar allegations, both unequivocally bribery allegations. The Johnson allegation, a specific reference to a taint of fraud. Now, the court may have, will have read Close Brothers' opening remarks, paragraph 2 of their own skeleton argument, where they open their submissions by saying that a £183 commission by lender to dealer was a routine arm's length and legitimate commercial tripartite agreement between buyer, seller and lender. It would not be regarded as a bribe in the ordinary course of that word or as a matter of common sense and should not be so regarded as a matter of law. Well, they refer to the commercial tripartite arrangement and they make that observation. We endorse that sentiment, but I think it would help to understand the arrangement between the motor dealers and the bank show some light.
Tripartite, is it?
Well, it's not really
In any
tripartite.
sense.
No. Well, but it will help, my lady, to look at the agreement.
What you've got is you've got a sale by the dealer to the lender you've got a hire purchase agreement between the lender and the borrower, and you've got some kind of relationship which is non-contractual between the borrower and the broker.
My lady, absolutely. Tripartite was perhaps an unhelpful word.
Three separate
Yeah.
relationships, two of which are contractual.
Absolutely. But I do think it would help to understand the arrangement between the bank and the dealer, because this is one part of the sort of commercial structure that we haven't looked at. And if I could ask the court to look in the supplemental bundle of reg, and it's tab 9. So it's page 45 of the supplemental bundle.
Yes.
And what you see here is it's a Motonovo Finance document. You see that top right. That was the trading name for the business written by Firstrand Bank between 2012 and 2019. You'll see that the document is written to Mr. Richard Szabo of TT Sports and Prestige Limited. And just to be clear, they were the dealer, TT Sport, in the second of the two hire purchase agreements involving Mr. Wrench, the 13th of March 2017 agreement. And so this document sets out the business relationship between my client and that particular dealer, TT Sports. And you'll see at the first paragraph, under business relationship, we're pleased to confirm the rates and terms agreed, referred by you to Motonovo, by submitting applications to and accepting advances, commissions, bonuses. The dealer accepts and agrees to be bound by the full terms and conditions as laid out in our dealer terms of business. So if I can then turn down to look at the terms of business, please. They are at page 48. You'll see the general terms. I hope top of page 48 you'll see the general terms. And can I ask the court kindly then to turn down to page 50, and it's clause 1.15 I'd like to ask the court to consider, because this is a clause stating under the heading commission disclosure, you agree to disclose to the customer early in the sales process in relation to each regulated finance agreement that commission may be payable to you for acting as a credit broker and or credit intermediary. If requested to do so by the customer, you'll inform the customer of the amount of any commission and other benefits payable by us to you in relation to the prospective or actual regulated finance agreement. And so, to be clear, and it's obvious, my client required the dealer in this transaction, TT Sports, in this business relationship, to do two things. First, to disclose to the customer early in the process that commission may be payable, and secondly, if requested by the customer, to inform the customer of the amount. So that is the TT Prestige dealer. Now, in relation
Does that include the share of revenue profits as well?
Well, it's not prescriptive about the precisely what is meant, does it? It seems
So it's similar to the one that we were shown this morning by Mr. Weir. I note that we got the dealer commission, hire purchase, etc. We've got various uplifts.
Yes.
And then this thing called an advance revenue share in relation to advances. So they're getting a cut on that as well.
So, my lady, that plainly would be part of the commission. And respectfully, I'd submit that, yes, that would fall within both parts of this, may be payable. And if, of course, in particular, if the customer asks, well, that they are required by my client to inform the customer of the amount. What I did want to also say is it was explained by the bank's witness that they hadn't been able to find the equivalent document for the other dealer. First Lane Motor Cars was the dealer in the first transaction. Yeah. But Mr. Scott Wood's evidence, para 52, we don't need to look at it, was his belief, and it wasn't challenged at trial, that there would have been the same rates and terms applying to that dealer, and the same clause 1.15. So those are the bank's bespoke rates and terms. but as you've what Mr. Scott Wood also explained is that the rates and terms incorporated the lender's terms of business. And if I could just go to look at the more general lender's terms of business as well, that is down, please, to page 58. 50. Let's just have a look. No, 57, I'm so sorry. 57, it's small print, difficult to read.
Yep.
Apologies. But top of the page, you'll see dealer terms of business with Motonovo Finance, a division of Firstrand Bank. And then if you kindly turn the page to 58, and this certainly gets very small print. But if you look kindly at 3.2, about a third of the way down the page, you may be able to read the dealer undertakes to M&F to act in accordance with all applicable laws in introducing applicants to M&F, including without limitation the FCA handbook rules and guidance on treating customers fairly. Now, there are a whole plethora then of things that my client required the dealer to undertake to do, but if you kindly focus at the 3.2.14 and 3.2.15, you may be able to read, certainly if you magnify it on the screen, the undertaking to disclose the fact of a commission payment from M&F to the dealer, and then 3.2.15 to disclose the amount of commission from M&F to the dealer on request. And so one again sees that distinction, but both in the bespoke rates and terms and in these terms and conditions between the obligation to disclose the fact of a commission and on request to go further and to disclose the amount.
Sorry, just a second. What 3.2,
So
the first few words you've drawn our attention to. And what does it say about the subparagraphs which follow, the numbers?
I'm so sorry. So 3.2.14.
Yes, I've got that, but I'm just wondering what it means. These are things which the dealer has agreed to do, are they?
Yes.
Yes.
Okay, so to disclose the fact of it, not that a commission may be paid, but the fact that one will be.
That is the wording of this.
Fact of a commission.
So that's different, isn't it?
Yeah.
From what they actually.
That is correct.
Well, there's a conflict actually between the two, isn't there? Because I think that the word "may" is used in the.
In 1.15,
Yes.
absolutely, the rates and terms, it was commission may be payable. So that
Yes.
was in the document.
But the small print says you've got to disclose the fact that a commission is paid.
Yes.
And when I'm so sorry.
Sorry.
And when your clients, the bank, make a disclosure in their terms and conditions of the hire purchase agreement, they only disclose that it may be made.
That's absolutely correct, Michael.
Yeah,
That's absolutely correct.
And we have to assume that as a matter of construction of this agreement as a whole, which of course the customer won't see anyway, that the word commission in the main agreement embraces the profit, even though the word commission is used distinctly under the general terms and conditions as something different from a finance share.
My lady, yes, I acknowledge that and certainly want to come back to it. What I did want to just say before leaving this page 58, is when looking at that clause 3.2, there's obviously a requirement for the dealer to act in accordance with the FCA handbook. And I just wanted to consider why a lender, a well-advised lender such as my client, would require motor dealers to disclose commission payments in that context. And the fact is, and this is common ground, by the time of the hire purchase agreements in range, so 2015 and 2017, it is common ground that the regulatory position in relation to commission disclosure had tightened. And from the 1st of April 2014, so about 13 months before the first agreement, disclosure of commission by credit brokers was required in certain circumstances. And if I could just show the court additional authorities, that's not one we've looked at, tab 56, page 1578. So 1578 of the additional authorities.
Which volume?
Oh, well, I'm...
Formal.
Thank you.
Yes.
So 1578, it's tab 56.
This is Conc 4.5. Yes.
And halfway down the page of this document, there is a heading, Commission's Credit Brokers. You'll see that it's a Conc rule, for Rule 4.5.3, 1st of April 2014 is the date, and a credit broker must disclose to a consumer in good time before a credit agreement the existence of any commission or fee or other remuneration payable to the credit broker by the lender in relation to a credit agreement. I'm obviously focusing on the relevant terms, which where knowledge of the existence or amount of the commission could actually or potentially, one, affect the impartiality of the credit broker in recommending a product, or two, doesn't arise. So this is a regulatory obligation, obviously imposed upon credit brokers, here the dealers, not the lender, and it requires disclosure of the existence of a commission. That's the word at the beginning of the second line. But then if you look at the next rule, 4.5.4, you see the further requirement at the request of the customer. 4.5.4, a credit broker must disclose to the consumer in good time before an agreement the amount, or if the precise amount is not known, the likely amount.
It occurs to me, Mr. Hardwick, that it's very peculiar that the regulator and the lender, in circumstances very responsibly, would make these requirements if, as a matter of law, there was no obligation on the broker to do any of these things, or they weren't in a fiduciary relationship with the customer.
Well, my lady, respectfully, our position, as you will well understand, is that we required our contractual counterparty, the dealer, to disclose commissions in accordance with the Conc provisions. That's obviously why we were doing what we were doing. We're also a regulated entity. We take that authorization seriously, and we require those with whom we contract to act in accordance with the Conc rules.
But it's not a criticism of your clients, it's just an observation that there would be no point. I can well see why your clients would require it. I can well see why the Financial Conduct Authority would require it of people. Your clients want to make sure that the brokers are behaving responsibly.
Absolutely.
Because there is a danger that if they don't, it will come back and bite your clients, to use the vernacular, and you want to protect yourselves against that. And all of that flies in the face of the suggestion that there is no potential liability in the event that they don't do it.
My lady, we don't accept that, but just in relation to the observation your ladyship absolutely rightly made about why any well-advised lender would want to be prescribing these, but there is a further provision of the Conc rules, not actually in the bundle. It's Conc 1.2.2, and I can see your ladyship is well aware of it, which requires firms to ensure that its employees and agents comply with Conc, and two, to take reasonable steps to ensure that other persons acting on its behalf comply with Conc. Now, I'm not going to get into any sort of debate as to whether that applies to the bank, and I know there are lively debates about whether that applies because it can engages agency and employees and others. But your ladyship is absolutely right in observing that, of course, a lender in my client's position wants to be careful and requires contractually those with whom it does business to tell consumers about the fact of commission, and if asked, the amount of commission. And of course, in this case, my client went a step further because it disclosed the commission in its hire purchase terms and agreements. This is the relationship with the dealer. And obviously, and you'll well understand that my client is not in a customer-facing role. That the customer-facing role is that of the dealer and the credit broker. So we do two things. We require, we refer to the fact that a commission may be payable in our terms and conditions, but we also require the customer-facing dealer with whom we contract to disclose commissions. There is, let me just say, and I'm not going to cover this whole point now, I'm going to come to it later in Johnson, but there is a question, obviously, as to whether the dealers did disclose the commissions as they were supposed to do, as required by my client in this case. And it has to be said, and I'll just give an outline for the moment, that the evidence below in the two cases with which I'm dealing is less than satisfactory on these points. But just so the court understands what the lender's understanding was, can I just very quickly go to the wrench evidence? And this is in so supplemental bundle wrench page 19. So it's page 19, paragraph 12.
This is Mr. Wood's witness.
This is Mr. Wood, so he's absolutely the witness for the bank. His witness statement, 13th of March. And what he says at paragraph 12, and this is in relation to the first wrench agreement, 23rd of May 2015. He says, paragraph 12, about two-thirds of the way down, before applying for finance, I believe the first dealer, that was Firstrand Motors, would have given the claimant a document or documents that would have explained that the first dealer may or would receive a commission for the claimant's introduction, which he defines as the first dealer disclosure document. Because of the time which has passed, I've been unable to find a copy. So that's in relation to the first agreement. If you go down to page 21, paragraph 23, you'll see that Mr. Scott Wood says exactly the same thing about the second agreement. I believe the second dealer would have given a document that would have explained commission may or would be paid, but haven't been able to find it. And then just finally, if you kindly go to page 28, just to finalise that, it's page 28, paragraph 54. Mr. Scott Woods says, for the reasons set out earlier, the agreements clearly explain that commission may be paid, and that's relying on the HP agreement clauses. I also believe the first dealer disclosure document, the second dealer disclosure document would have told the claimant that the commission would be paid. So that was the bank's evidence that the bank believed that the brokers, Firstrand, TT Prestige, had done what they were supposed to do, but the copies of the documents had not been found. Now, just very briefly, as I say, giving an outline. In cross-examination...
I'm just wondering why the bank would actually have copies of those documents.
It didn't. It didn't.
No, but I mean, Mr. Wood looks for them and says copies haven't been found. Well, he wouldn't find them because the bank would never have them.
Absolutely right.
So he's just speculating, isn't he? He's hoping that they've done the right thing.
That may be right.
Yeah.
What is true is that there is very little, well, let me be more clear. Cross-examination, Mr. Wrench wasn't specifically cross-examined about this dealer disclosure document. It was basically put to him, he didn't read any of the documents. It wasn't put to him specifically that he may have been provided with this, I acknowledge that. And in closing submissions, No reference was made by either party to the dealer disclosure documents. At first instance, Deputy District Judge Harrop, he referred to the evidence of Wood that he hadn't been able to find the document, but then there's no further reference in the judgment. And he doesn't make a finding either way as to whether this dealer disclosure document was provided, and nor does His Honour Judge Worcester. So that's range. On Johnson, just again so the court understands, and I'm going to go into this in a bit more detail when I come to the suitability document disclosing commission. But it's still more curious, frankly, because, and we don't need to look at it, Mr. Irving, the reference is page 9 of the supplemental bundle in Johnson. But now Mr. Irving, paragraph 10, says the same thing. Before applying for finance, I believe the dealer would have given a document which would have explained commission, but I haven't been able to find it. That's at page 9 of the supplemental bundle in Johnson. It's paragraph 10. I think your ladyship might be looking at it. So very similar claim, identical claim.
Is there a copy of a document? They haven't found the actual one.
Yes.
Is there a copy?
There is. It is the suitability document. And that's, I'm going to come to this in a moment, but this is why it is passing curious. But but it chimes with what your ladyship said a moment ago. That absolutely right. My client doesn't have this. Not its client's document.
Doing it all on trust. The bank can't do much more, frankly, than say to the dealer, look, we expect you to do this, 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 and this. Assume that the dealer has done this, 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 and this.
That's right.
And then it will be for the dealer, if there is a disclosure.
That's right.
To disclose whatever documentation they produced, or if the customer happens to have kept a copy.
That's right.
For the customer to disclose.
And I will come to the provenance of the suitability document / dealer disclosure document in a moment, because it's quite important. But just so to give again an overview of what happens in Johnson about this dealer disclosure document, Mr. Irving of the bank says, haven't been able to find a copy. Mr. Johnson is cross-examined. He says he can't say whether or not the documentation he was given included this document. District Judge Sandercock referred to the dealer disclosure document, paragraph 21M of his judgment. He referred to Mr. Johnson's evidence. I didn't read the papers, including the dealer disclosure document. But he makes no other reference to it, the Deputy District Judge. He makes no finding as to whether the dealer did disclose the commission. And that is what was identified by His Honour Judge Harmon as to a reason for omitting the unfair relationship problem, because there hadn't been a finding of fact as to whether the dealer had disclosed commission. You may have picked that up when you were looking at the order of His Honour Judge Harmon. It was one of the points that troubled him and is identified in his judgment. Mr. Popplewell will be dealing with that, and it's probably best for me not to go further on that point, because it cuts into the unfair relationship.
I can foresee some difficulties generally with all of this, but carry on. I'll ask Mr. Popplewell in due course.
So you've heard reference to a suitability document, obviously, and it's a document centrally relied upon by the appellants.
That's the one at page 37.
Yeah, absolutely. So back, please, at that. Let's just look at it briefly. I'm going to come back to
it. Do we only just have it for Johnson?
Yes.
Yes.
We just have it for Johnson.
Yeah.
I'm going to look at it in a moment, more in greater detail, but just for the moment, obviously, all I ask the court kindly to focus on is the dealer disclosure commission sentence, which is about just before halfway down, isn't it? We do not charge a fee, but we may receive a commission from the product provider. So this is a document from the Trade Centre Wales. That this is the dealer in the Johnson case. And that appears to be how that dealer complied or purported to comply with its obligation to disclose commissions as required of it by the bank. My lady, my lords, I'm going to come back to that document, as I say, in some detail. But I wanted just the court to be aware of the contractual relationship between my client and the broker, really for two reasons. The first, generally, respectfully, is in relation to the instinctive inaptness of an allegation of bribery in such a context. And as the court has seen, Mr. Johnson, Mr. Wrench, they insist that my client in paying a commission to the lender are bribes, it's a fraud. And this court knows, and Wood is, Justice David Richards in Wood, absolutely clear as to the special category of bribery cases in English law, the strong policy reasons that underpin it, the corrosive nature of the practice undermining the country's social, economic and commercial values, and the evil practice identified by Lord Templeman. These are very strong words, the condemnation of the practice of bribery. But there is no case amongst the 13 which Lord Justice Richards considered in Wood, and there is not in any of the 65 authorities before this court in the core additional and supplemental bundle, in which the relationship between the alleged bribe giver and bribe taker was governed by a contract which required the alleged bribe taker to disclose the bribe to his principal. And I do make that point, and it chimes, I respectfully submit, with an observation made by my Lord Justice Birss yesterday. The great evil of bribery, as identified by Lord Justice Chitty in Shipway and Broadwood, is the secrecy attending the payment. The secrecy attending the payment. That's the real evil. But in this situation, my client contractually required the payment not to be secret. And that also leads to a related point, which is something that I develop in relation to the next issue. But it was central to Lord Justice David Richards' reasoning as to why a fiduciary relationship wasn't necessary. Was because the payer of the bribe is the primary wrongdoer. And that's the language of the Lord Justice. The payer of the bribe is the primary wrongdoer. And again, respectfully, as we sort of start this journey, it is not difficult to understand in the context of the bribery cases, Panama and South Pacific Telegraph, where £80,000 is paid to Sir Charles Bright, who's supposed to be the certifying engineer. Or in Shipway and Broadwood, where you had the horse vendor's payment to the very veterinary surgeon, Mr. Pinkett, who's supposed to be providing an independent valuation. One understands the primary wrongdoer appellation in those contexts. But in the context of a commercial agreement where the alleged bribe giver, the bank, required its counterparty to make disclosure, it is, let me just say at this stage, much more difficult to understand an analysis of the bank being a primary wrongdoer. But let me also say, I said I had two reasons, and look, that's just a sort of by way of overview, instinctive inaptness. The second is, of course, in relation to the dishonest assistance point. Because, and this is again something that I developed carefully in the second issue, if there's no bribery cause of action, the liability of the bank can only be as an accessory. We say that must be as an accessory to a fiduciary duty. The appellants claim that the bank can be an accessory to a breach of a disinterested duty. I'm going to come back to that. We don't accept that. But for the moment, all that matters is that accessory liability requires dishonesty. And I'm grateful for Mr. Weir bringing to the court today the lifestyle equities case. Obviously, the requirement for dishonesty is identified in TAN and Twin Sectra, but also at paragraph 98 of lifestyle. It's all completely common ground. Again, in relation to that assessment of dishonesty, where my client contractually required disclosure by the motor dealer, I respectfully submit there cannot be any question of dishonest assistance of a breach of fiduciary duty. I should say, none of the judges grappled with a breach of fiduciary duty anyway, because they didn't find a fiduciary duty was owed. So there aren't findings of breach of fiduciary duty. But anyway, I just introduced this contractual infrastructure to show that second point before going any further. So those were just some preliminary points that I wanted to make before getting into grounds 1A and B on the secrecy on the first point. And if I can anchor myself in our skeleton argument, please, at now onto about paragraph 20. I could take our first point, our point 1 and point 2, really very briefly. What we tried to do in the skeleton, and it's paragraph 20 to 24, is to look carefully at Firstrand and this essential distinction which is made between the level of disclosure sufficient to negate secrecy and, secondly, the level of disclosure necessary to obtain the principles informed consent. And we did that because what had troubled us was in the appellant's permission to appeal skeleton and in their appeal skeleton itself, they conflated these two. They actually stated that to negate secrecy, the burden was on the bank to show Mr. Wrench knew of and consented to the payment. That's what they said at para 69A of their skeleton and in other places. Now that was wrong, obviously. I'm not proposing to go back to Firstanger, paragraphs 33 to 44. It's very familiar terrain now. But plainly, Lord Justice Tuckey sets up this really very clear distinction between disclosure which is sufficient only to negate secrecy, I call that the negation of secrecy disclosure, and the more extensive disclosure, which is unquestionably required to obtain informed consent of the principal, and which is a defence to a breach of fiduciary duty. The negation of secrecy doesn't affect the fact that there is still a breach. So that was the point that we'd sought to make at paragraph 20 to 24, and I can jump through that quite swiftly. It's also the point that we make from paragraph 25, where we flag our concern that there has been a conflation of these two elements of disclosure.
It rather begs the question, doesn't it? And it may well be a question of fact and degree on the facts and circumstances of the evidence of each case. But what Lord Justice Tuckey talks about in terms of negating secrecy, if you tell somebody that something may happen, now what does he mean by if you tell somebody that something may happen? Now, in your case, presumably you're going to say, well, it's enough that you give them a document that informs them on the face of the document that something will happen, even though they don't read the document, or it's buried in the small print on page 22.
I do say that, and I'll be showing your ladyship where that is precisely the approach of Lord Justice Tuckey in Firstanger, paragraph 42, where the only disclosure, obviously the inadequate disclosure, but the disclosure sufficient to negate secrecy, the only disclosure in that case was as a result of the signature of the borrowers to a lender document which has a clause about the possibility of commission. And that's why we do say we are squarely aligned. Factually, there's no distinction between this case and Firstanger. Can I just address, so I'm making good progress. I don't need to go back, and with respect to Rob, Mr. Weir, of course, he didn't make that conflation orally, and I'm most grateful. It's important to keep the two separate, but obviously that was not a problem repeated orally. But one point which was developed was what it seems, a sort of attempt, it seemed, to make a distinction on the facts of Firstanger. And we've referred to this from paragraph 29 under our point 3, a distinction on the facts as to whether the borrowers were told in advance. Yes. And you were taken, my lady, my lords, to paragraphs 2, 3 and 4 of Firstanger yesterday. It probably is worth just having one final look at, so back in the core authorities, and it is Firstanger, which is at tab 4, if I could go to page 52. So it's page 52. Paragraph 4, you were taken to this by Mr. Weir yesterday. So page 52 of the core authorities. And what was drawn to your attention, in fact, if you start at the bottom of paragraph 2, you can see the defendants were sent 3 documents by the claimants. And paragraph 4, there's a longer document. So this has come from the claimant then, saying, please read this communication carefully. By signing same where indicated, you confirm you have studied and understood the contents prior to our proceeding further with your application for a loan. And then you have D, which is the point your ladyship made yesterday, the broker assistant is acting as our agent. And then about 4 lines down in D. And of course, we've no real idea of the length of this document. We've just got D here. But line 6, in certain circumstances, the company does pay commission to the broker. It's also just worth having in mind that this wasn't the loan agreement. This is a separate document. So it's nothing to do with the terms of the agreement per se. It's a separate document sent by the lender. But then if you go, please kindly, to, and I just referred to paragraph 42 of Firstrand, I could ask the court to look at page 61. Paragraph 42, and we didn't look at this yesterday, just having looked at the pleadings, the written submissions, and the recorder's judgment, it seems to me it was common ground between the parties at trial that the only disclosure made to the defendants was by means of the claimant's document, which we just looked at, which the defendants signed. The broker's letter said nothing about any disclosure we'd made, nor did Mr. Fellows suggest that anything else had been disclosed by anyone. By signing the document, the defendants must be taken to have understood what it said, but no more. And so that, as I said, my lady, that is it in Firstrand. And that is sufficient for Lord Justice Tuckey's analysis to hold that it's obviously not good enough for informed consent, but it is good enough to negate secrecy.
You rely on 44, which describes the passage as muddled.
Well, but that's getting into the informed consent.
Well, yes, exactly. But you're saying, notwithstanding that it was muddled, etc., etc., Lord Justice Tuckey said it was enough to negate secrecy.
With respect, I see a distinction between 43, which is about secrecy. Did it negate secrecy? I think it did. If you tell someone something might happen and it does, I don't think the person you told can claim that what happened was a secret. So the negation of secrecy, the inadequate disclosure, that's enough on the basis of the signed document. 44 is then looking as, was there informed consent? And that's where Lord Justice Tuckey says, no way. It's a muddled document. It's not good enough. And of course, for the purposes of the appeal, we're entirely content to accept that there was inadequate disclosure in our hire purchase terms and agreement. We can't say otherwise for the purposes of these appeals. But did it negate secrecy? Yes, for precisely the reason identified by Lord Justice Tuckey in Firstrand at paragraph 42C. There's just no difference. There's no difference in the facts of this case.
Do we know whether the evidence in Herstanger was that the document was read?
Well, what you have is paragraph 42, which, in my respect for submission, is everything one needs.
We just don't know what the judgment says.
Broker's letter said nothing. Mr. Fellows didn't suggest that anything else had been disclosed by anyone.
Yes, that doesn't suggest that anybody said anything about it, but we don't know, do we, whether or not the evidence was that it was read, or whether there was a fact finding by the recorder that it was read.
My lady,
we've got a finding that it was signed.
Yes. So, if I could, I'm going to sort of circle back to a very similar comment by Lord Justice David Richards in Wood, paragraph 127. But I'm not going to quite go there quite yet, because before I do so, I want to come to ground 1B.
Actually, in fairness to you, Mr. Hardwick, paragraph 41, we do not know, this is between C and D,
very good,
we do not know what, if anything, they were told by the broker, or what they understood from the document which they signed.
That's the answer.
Well, something in 42. I'll tell you over lunch.
So, As I say, in our skeleton at 32, we say the right approach is the Lord Justice Tuckey approach. At paragraph 43, if you tell someone that something may happen, the secret is out. That's a statement of law that the other parties accept. I'm going to come back to the signature point, if I might, but can I just, taking this in order, come next to what we read really is the key argument on this ground, that there is this requirement to draw attention to the commission term. This is their ground 1B. We looked at their notice of appeal and their grounds. And it's an argument that is raised throughout their appellant skeleton, 78, 80, 82, 84, that there was a duty to expressly draw this clause to the claimant's attention. And that had to be done. It was necessary to negate secrecy, to do this express. Now, we say, and you'll have seen what we say at paragraph 34, that this just repeats the very same error that was made below at first instance by the judge when he misreads or misapplies what Lord Justice David Richards said about paragraph 120 in Wood. And again, I'm very grateful for Mr. Weir because he's essentially done the groundwork in relation to this. But there's just one other thing I would like the court to be aware of. If I can just go back to core authorities, tab 11, and the starting point is at page 271. So 271, 2/3 of the way down the page. Two-thirds of the way down the page identifies the issue that the judge is considering at this point in the judgment. Did the broker owe a fiduciary duty? Again, Mr. Weir pointed that out, and I'm grateful. If you then kindly turn down to 274, you'll see these passages at 119 and 120. And again, actually, Mr. Weir took you to 119. It was Mr. Lord of the lender relying on the term that the broker might receive fees from lenders as being inconsistent with the duty of loyalty. So this is the point the bank is trying to argue. There is no fiduciary duty, and saying, look, there is a term saying the broker might receive fees, and Lord Justice David Richards' submission is, well, that can't work with Firstrand. But he also, at 120, says, I would also add that in my view, the broker could place reliance on this term only if it expressly drew the client's attention to it. And then, although Marcus Smith proceeded on the basis of Mr. Pengelly had actual knowledge, Judge Carr found Mr. Pengelly so completely trusted the broker didn't read the documents. By signing the acceptance form, Mr. Pengelly knew or was deemed to know the term. There's no finding that Mrs. Wood knew of the term. So that is clearly an additional analysis made by Lord Justice David Richards in the context of the fiduciary duty point. But when you then come to his different analysis at issue 3, were the payments made in these cases half secret? What we didn't look at yesterday, but what's important, is 127, because here David Richards goes on to say, as earlier mentioned, the appellants contended the commissions were half secret. What is meant by this is that the borrowers in each case knew, or they would have known if they had read the terms of business, that the broker might be paid fees by lenders. And so would have known if they had read the terms of business, we respectfully submit, cannot stand with a requirement that such a clause has to be expressly drawn. It doesn't make sense, they don't stand together. And actually, this is what His Honour Judge Worcester completely understood, and we respectfully submit got absolutely right. And if I could turn the court's attention to the passage of His Honour Judge Worcester, which is of course the one being appealed, it's back in the core bundle at 21, page 263. So we're looking in the judgment of His Honour Judge Worcester and it is at paragraph, so core bundle 263, sorry, it's paragraphs 9 to 11, absolutely. And if I pick up at 263, and take this quite quickly, 263, beginning paragraph 7, I'm sorry, not being clear on the references. You look at 263, halfway down the page, decision of His Honour Judge Worcester. Ground 2 of the appellant's notice is a challenge to the judge's reading of paragraph 120 of the judgment in Wood. It said the judge erred in finding commissions were secret. The commission may be payable to the term had not been expressly drawn. So that's the point. Paragraph 8, Mr. Hibbert submits the judge has taken the passage out of context. I agree. And then the judge looks at the subheadings that we've just looked at, 1, 2, 3. And the judge explains he deals with issue 1 at certain paragraphs. Issue 2, paragraph 120 appears in the part of judgment dealing with whether a fiduciary relationship existed. 9, it's argued by the brokers in Wood that the terms of agreement to effect the broker might receive fees was inconsistent with duty. We've looked at that. And then the judge says that's the content for the context for the passage relied on. An argument which went to the existence of a fiduciary duty and not to the issue of whether or not the secrecy was negated. And he makes a further forensic comment about I would also add, absolutely right. And then says the point is that not only did the submission not stand with Firstrand, the term would have to be drawn to the attention of the client for it to have any effect. The Court of Appeal is not saying that to negate secrecy, this term has to be expressly drawn to the attention of the client. Para 11, the question of whether the payments made in ruin but half secrets is issue 3. So, respectfully, my lady, simply say that His Honour Judge Worcester's understood this completely correctly. And there is nothing erroneous in his understanding of the analysis of David Richards in Wood, and there is certainly no statement or suggestion that there must be this express attention requirement in order to negate secrecy. One further factual point that was developed yesterday, and certainly developed, perhaps I should say more accurately, in para 37 of the appellant's skeleton, is that there's some important difference between the lender document in Firstrand, the one at paragraph 4, the one that says please read this communication carefully and by signing you confirm you've understood and studied. There's something of an important difference between that and the signed hire purchase agreements in our case, and that somehow that is sufficient to distinguish these cases. Now, that, respectfully, we submit is not right. Mr. Wrench has signed 2 formal hire purchase agreements in relation to my client in this case. And if I can just ask you to look at the signed hire purchase agreement, it's the supplemental bundle in Wrench, and it is tab 7. And it's page, so that is that's the hire purchase agreement, page 39. So supplemental bundle in Wrench, page 39. And if you scroll down to 41, you see the signature box at the top of the page. Again, not easy to read because it's slightly smudged, this copy. We tried to get a better one. But you'll see at the very top, this is a hire purchase agreement regulated by the Consumer Credit Act. Sign it if you only if you want to be legally bound by its terms. He signs it underneath. And then the next box, signature by you of this document is an offer on your part to enter into an agreement on the terms set out herein. In those circumstances will it become binding until accepted by signature for and on behalf of Motonovo. And then there is also this customer declaration that appears below that. The customer understands that Firstrand Bank, as the creditor, will rely on the truth of this declaration. By signing this agreement, the customer declares that the details are correct, 1. 2, the customer has had his attention drawn to the provisions of clause 10. 3, the customer declares he/she has received and read the pre-contract information. So
Is pre-contract information defined?
I'll tell you what it is. It's at tab 6. You'll see pre-contract credit information. It is a statutory required document under section 55, and it sets out the required details under the 2010 regulations.
Yeah.
But my lady, just back, if I might, at those signature clauses, they are respectfully formal warnings above and below Mr. Wrench's signature. Sign it only if you want to be legally bound. Signature and offer on your part. They are no less formal than the please read this communication carefully in the Firstrand document. And they are warnings which fulfill the same function of spelling out the legal effect of signature. In Firstrand, the borrower was told by signing the same, you confirm you've studied and understood the contents. Here, Mr. Wrench is told, sign it if you want to be legally bound. Respectfully, there is, we'd say, no difference. But the other point that has been looked at briefly is the reference to the terms over leaf. And you'll have read in the appellant skeleton argument a point made perhaps less emphatically in oral submissions, is look about 2/3 of the way down this document, 41. It's on the right. You see, it's page 3 of 3, which is right at the bottom. 2/3 of the way down, underneath the text on the right, page 3 of 3. So, does your ladyship see that? I'm not being clear. 2/3 of the way down, page 41. Yes. So it's a 3-page document, the hire purchase agreement, and then it's common ground that the terms and conditions which appear next, that's also a 3-page document. Yeah. We understood the point in it. There's not a sort of single run between the hire purchase agreement and the terms and conditions.
So you've got standard terms, the usual sort of blurb which nobody ever expects a consumer to read, and you've got something which specifically says you promise us that you've read clause 10, which is about something completely different.
Yes. Can I just make an observation, though, my lady, that I was just trying to deal with the sort of suggestion that's made in writing, certainly by the appellants, that, look, these are 2 3-page documents. Can I ask you just to look at the very bottom of the page? So you looked at the page 3 of 3. Do you see a 12 there, my lady? So page 41.
There's a 13 on the top
yes,
of page 42.
Yeah, but at page 41 there's a 12.
Yes.
So and His Honour Judge Worcester, what's going on here is there's a pack of documents, and it's something noted by His Honour Judge Worcester. We don't need to go to it. It's paragraph 23 of his judgment. But there is a pack of documents provided here, and forming part of the pack of the document we just looked at, the credit, I think that was page 6. Yeah. You can see that this is page 12 of the pack where Mr. Wrench has signed. If you go to the terms and conditions, you'll see it's page 13 of the pack. Yeah. So it just follows, it's just one sequentially numbered pack of documents.
It's not sequential number, page 8, it says on page
40 is page 8.
That's because what has happened in the preparation of this bundle is someone has spliced the unexecuted hire purchase agreement with the final page of the executed hire purchase agreement.
Because there are 2 copies of it.
Yeah, the pack contains an unexecuted and this is obviously now the executed.
Seems a bit strange because it says page 2 of 3 and then you've got page 3 of 3.
I mean, that's my understanding.
It's from 8 to 12, so it's a bit weird. But it may not matter, Mr. Hartwick, whether it's that or not. I mean, I don't see what the point is that anybody is making about the sequence of the documents. There's a cross-reference to the terms and conditions, and we can all see what the terms and conditions are.
All I was trying to explain is the reality of overleaf when the borrower receives these documents, signs the signature page is page 12 of the pack. The terms and conditions overleaf. This is the next
document. The reality is that he gets a bunch of documents. He probably glance over them. If he glances over them at all, he certainly won't read them, and he's signed on the dotted line. That's why the Consumer Rights Act and the Consumer Credit Act are formed in the way in which they are.
My lady, I do accept that. But the only other point I wanted to make is, and again, I'm doing this exercise to try to understand how the appellants distinguish these facts from Firstrand. And as I said, there's this reliance on the express attention clause, which is wrong. but we detect some reference that they accept that express attention was drawn to clause 10 by the signature, and that's at page 44. And obviously you've got the commission clause, which is 3 inches lower down. And we don't quite understand. Are the appellants saying that it's good enough for clause 10 but not clause 12?
Well, what they're saying is that their reference, as I understand it, rightly or wrongly, Mr. Weir's point is there's a distraction by a reference to clause 10, because specifically highlighting clause 10 as having a particular importance, which highlights it to the consumer, but nothing is said about clause 12, which is supposed to be particularly important. So the indication is, well, you should read clause 10, but you don't need to bother with the rest of it.
Well, if that is said, my lady, I would respectfully submit that would be an unfair submission. Your ladyship is well aware of the importance of the liability clause and the reference to statutory rights in that clause. Clause 12.6 fulfills a different function. And as I said, it's the bank's safety net to an extent. It's required its contractual counterparty to disclose commission, but it's also disclosing commission in its own document, which the customer has signed. And just can I just very briefly on this sort of incorporation point, because you've been taken to the reference to His Honour Judge Worcester saying it's not a question of a term, whether it's a term of the agreement. It's a matter of fact, and we accept that. Negation of secrecy is not a question of whether it's a term of the contract, and we know from Firstrand it wasn't a term of the loan agreement, it was a separate document. And you can disclose commission orally or in an advert or by any document.
Well, it depends whether you've done sufficient to bring it to the attention of the other party. And that must be a question of fact and degree, and you can rely on Firstrand, which says that they don't have to have read it if you've done your part. And it seems to me that it must turn upon the particular document whether you have, or whether it's sufficiently apparent on the face of the document or not. And there may be a distinction between a case in which it's there on the front page in reasonable typescript and one where it's buried away in the terms and conditions at the bottom. I don't know, but you would say not. You would say it's enough that it's in there, and it's enough that it's mentioned, and that the customer says that they accept the terms.
Well, it's interesting. Your ladyship mentions the point about the sort of the red, the familiar incorporation legal points about red lines and etc. etc. Of course, His Honour Judge Worcester's observation is we're not there. That's not what we're doing. It's not. No one needs to prove this is a term. It's sufficient to negate secrecy? A question of fact.
It's got, if it's sufficient to negate secrecy, something must be done to make it open enough.
That's obviously precisely.
That's got to be a question of fact and degree.
And as to that question of fact, District Judge Harrop finds that secrecy has been negated. His Honour Judge Worcester, paragraph 27 of his judgment, says he was, I quote, in no position to reach conclusions on the fact that were different. And we respectfully submit that to the correct, right appellate approach in this case.
In fact, do you say this was at 12.6, the commission may be payable? Is that in fact a term of the contract? Or is it just a statement of fact?
Well, if I was pressed to argue it, I would say it's a term of the contract. But I don't need to argue that. Because
but it is in a document which is purporting to set out terms of the contract. So it'd be a funny place to find something which wasn't a term of the contract.
I agree. But I'm prepared to accept that His Honour Judge Worcester's right. It's not really a question of incorporation. And I do think that changes with Lord Justice Tuckey's approach in Firstrand, where he's not looking actually at the loan agreement at all. He's looking at something separate. And obviously, commissions can be disclosed in other ways, orally or by advert. So it's a question of fact.
I don't think there's anything between you and Mr. Weir on that, because he doesn't say it's a question of incorporation
either.
No,
I think there's absolutely nothing between them. But, I mean, really then, you'll have seen the way we draw this together in our skeleton argument at paras 40 and 44, having looked at this quite carefully. We say that we are absolutely in Firstrand and Wood terms, in territory. Mr. Wrench hadn't read them. But if he'd read the terms, Lord Justice David Richards in Wood 127, he would have known that a fee might be paid. By signing the credit agreement, he must be taken to have understood what they in their terms said, but no more. Lord Justice Tucky Hurstanger, para 42. And we are then met, as we've cited it at 41, by this constant refrain in the written argument that we didn't do enough to prove knowledge and consent, which again we say that's the wrong test, nothing to do with either, certainly not consent, and not actual knowledge either, because of the learning of the two justices in Hurstanger and Wood. The secret was out, as Lord Justice Tucky puts it at paragraph 43. And there was no fraud, and it would be unfair to visit the bank with a finding of fraud, again, to deploy those observations of Lord Justice Tucky at Hurstanger. And really, that to some extent dovetails with my opening points. This is the case law doesn't draw a distinction between secret commissions and bribes. A bribe's a finding of fraud. The facts of this case are a paradigm case of the Lord Justice Tucky halfway house, and we prefer the term halfway house to half secret. That's actually what Lord Justice Tucky referred. We accept that this disclosure, for the purpose of this appeal, was inadequate. It didn't do enough to get Mr. Wrench's informed consent, but it's not a fraud case. We required the dealers to comply with the FCA handbook. We required them to disclose commission. We took a further step of including the term in our terms and conditions, which was included in that document pack which Mr. Wrench signed. This was not a secret commission. So that, I think, concludes my submissions on that first issue, and whether it would now be an appropriate moment for 5-10 minutes.
Yes, if you'd like. We'll rise for, should we say 5 minutes?
These ones from the court. We took from. Oh, these are. No, that's fine. I was just making sure we weren't stealing the course ones.
Brilliant. Yeah, good one too. Yeah, good.
Well, I know, that's why I like to stick to the good old-fashioned way.
All rise in favour. Yes.
My lady, my lords, can I pick up then at the paragraph 42 in our skeleton document?
Yes.
The heading, whether the disinterested duty is sufficient in halfway house cases.
Yes.
That's paragraph it's page 63, I think, of the core bundle.
Yes.
That is the issue I now want to engage with, and as I've indicated, it's both arises in ground 2 of the Wrench appeal and ground 1A of the Johnson appeal. Essentially, the judges were both wrong. Judge Harman is on the Judge Worcester to hold that in a halfway house case it was necessary for the brokers to owe a fiduciary duty, that the disinterested duty would suffice. And we make 6 points, and I can take the first 5 pretty rapidly. The first point, of course, you see produced there at 43 is that the ambition is evident from the fact that it wasn't an argument raised below, and we have cited paragraph 31 of the Johnson trial skeleton argument, where precisely the opposite tack was taken where a commission is half-secret. Liability depends on owing a fiduciary duty.
Right, that's the jury point out the way.
Well,
Next
there
point.
it is, yes. So let's go on to point 2, which is over the page. Herstanger, McWilliam, Wood and Midstead established the necessity of a fiduciary duty in half-secret cases. All of these 4 Court of Appeal authorities refer to the necessity of a fiduciary duty in half-secret cases. In view of the time, I'm not actually, I think that the easiest way to do this is simply to go straight to Wood in the first instance to see what Lord Justice David Richards says about the necessity for a fiduciary duty in half-secret cases. And if I could ask the court please to go to Core Bundle 11 at page 239.
Yeah.
Sorry, so 266 actually is where I'd like to start. And forgive me, but just for the purposes of this analysis, I'm just going to go to the references where Lord Justice David Richards says fiduciary duty necessary in these 4 cases. I'm going to develop some of the points in the further points. But if you start please with 266, paragraph 80, and this is the review, Lord Justice David Richards' review of the 13 cases in relation to what's the necessary duty for bribes. He says of the recent authorities, the first is Herstanger. As I earlier indicated, this is important. The 3rd issue of a half-secret commission. It's also illuminating on the issue of the necessity for a fiduciary relationship. I'm going to come into the explanation in a moment, but just for the moment, you'll see the reference to the necessity for a fiduciary relationship in a half-secret case. If I can move to the reference in relation to McWilliam, please, that's at paragraph 84, and it's the last sentence of paragraph 84. McWilliam referred to, and then Lord Justice David Richards says, applying Herstanger, a fiduciary relationship was necessary for the borrowers to succeed, given that the commission was half secret, which is of course the shorthand that's been used for the halfway house case. So that's the McWilliam fiduciary relationship necessary. The 3rd reference, if I could ask the court to go down to paragraph 88. And the reference is line 5, paragraph 88. It was therefore another case of a half-secret commission, and in line with Herstanger, it was necessary to decide whether the broker owed fiduciary duties to the clients. And so, as we say in our skeleton, and that's really just a quick way of looking at it, those Court of Appeal authorities all support the proposition that in a half-secret commission case, the identification of a fiduciary relationship is necessary for relief. That brings me on to our point 3 in the skeleton, which is at paragraph 50. And this is much more important because this now looks at the analysis in Wood of the adequacy of the disinterested duty in bribery cases. And of course, the appellant's argument here is that just as a disinterested duty was held in Wood to be sufficient in secret commission cases, that it's also sufficient in half-secret cases. But we say that that's wrong, and it's important to have in mind these 2 stages in Lord Justice David Richards' analysis. Stage 1 is the why question. Why is a fiduciary relationship not a precondition in bribery cases? And stage 2 was to examine the case law and essentially see if that supported the proposition. And can I just then start with the stage 1, which requires one to go back in the judgment, please, to page 253. And it is 253 is where the issue is identified. So halfway down page 253, so core authorities, page 253.
Yeah.
And one sees the judge halfway down the page simply setting out that issue 1 is a fiduciary relationship between the client and the broker, a necessary precondition for relief against the payer of undisclosed commission to the broker. And to understand why that issue is so important. You see the competing first instance conclusions if you go down to paragraph 20. So Mr. Pickering in the Wood case, so paragraph 20, this bottom of page 253, after a careful review of many authorities, Mr. Pickering, the judge in the Wood case, concluded that a fiduciary relationship between the claimant and the payee was not a precondition to relief against the payer. The existence of a fiduciary duty and a breach of that duty provided an alternative route to relief. All that needed to be established was that the payee was the agent of the claimant and the three matters identified by Mr. Justice Slade in Industries in General. So that bribe test, which is familiar, set out in the Industries in General case. So that's Mr. Pickering. Fiduciary relationship is not a precondition. But if you then see the sharply different view of Mr. Justice Marcus Smith, which is down at paragraph 23, top of 255, so this is para 23. Marcus Smith, J, held that a fiduciary relationship between Pengelly, so that was in the other case, and the broker was a necessary precondition to any relief against CFBL or its assignees. I'm going to be looking at those cases a bit closer in a moment, but just to see that sharp conflict between the two judges at first instance. And that is, of course, why Lord Justice David Richards is grappling with this precondition question. And what I could, if I could then ask the court, please, to turn down to the discussion section, which is at bottom of page 258. Bottom of page 258, under discussion. What Lord Justice David Richards says is in what follows, I refer interchangeably to agent and pay in inverted commas without intending to suggest there must be an agency relationship before an undisclosed payment can in law constitute a bribe or secret commission. That's the first unambiguous reference to bribe or secret commission. 41, in approaching the issue whether a fiduciary relationship must exist, it's important to go back to the policy of the law which underpins its approach to bribery or the making of secret payments. That's again the bribery context. 42, the law reflecting the views of societies for a very long time set its face against bribery as a corrosive practice. And then we have all those familiar cases. And then 43, this passage makes clear that the meaning of a bribe, for the purpose of civil remedies, extends beyond its popular connotation of a corrupt payment. Then we get 44, the vice involved in the payment of a bribe for the purposes of the civil remedies. It may induce the payee to depart consciously or otherwise from the duty he owes to another person. So at the moment, what one sees unmistakably is that this special category of bribery is the context for Lord Justice David Richards' analysis as to whether a fiduciary relationship is a necessary precondition. That's absolutely clear.
It's hardly surprising because the case he was dealing with wasn't a halfway house.
Absolutely, correct. Absolutely. That is, I do agree. But remember the ambition of the appellant's point that you can read across the disinterested duty in a half-secret case, which is not what Lord Justice Richards was engaging with at all. 45 is the next paragraph, which the court hasn't been referred to yet, but it's important. The circumstances in which such a duty may be owed will vary greatly. Some may involve persons who clearly owe fiduciary duties in events such as trustees, directors, employees. But perhaps the other extreme, a person may be retained for the purpose of giving a single piece of advice. In any of these cases, and in the many other cases that would arise, the person owing the duty is at a risk of being suborned by a payment or offer from a third party as an inducement to favour the payer of others. Now that is an important passage in our respectful submission when understanding the reasoning of David Richards, because his real concern is the other persons, outside the paradigm category of fiduciaries. He refers to an example of a barrister in paragraph 67, not one would normally associate as being a fiduciary. But his concern is the range of circumstances in which a duty may be owed, which causes his concern as to the risk of requiring a fiduciary relationship. And you get this at 46. This is what Mr. Weir referred you to this morning at about 10 o'clock. We think it's absolutely at the heart of this entire decision, where he explains the risk inherent in requiring a fiduciary relationship as a precondition for remedies in respect of bribes is that either the civil remedies which should be available will be denied, or the term fiduciary will be applied so widely as virtually to deprive it of concept. It's just a critical part of the reasoning. The two reasons of the danger of insisting on a fiduciary duty as a precondition to bribes. One, you might deny meritorious cases, counter to the policy imperative of taking a hard line on bribery. Two, there is the related jurisprudential risk of applying the term so widely as to deprive it of content. And so that really then comes to the 48, the conclusion, to ask in cases of this kind, so again, we're firmly in the bribery context, whether there is a fiduciary relationship as a precondition for civil liability in respect of a bribery or secret commission, obviously bribes, is an unnecessarily elaborate and perhaps inaccurate question.
You're glossing over the word secret commissions.
Yes, saying that there's no distinction in the case law between bribes and secret commissions. Not half secret. Bribery or secret. So the question I consider is the altogether simpler one, of whether the payee was under a duty to provide information, advice, or recommendation on an impartial or disinterested basis. So that's really where you get to his conclusion. That's the why. Why should a fiduciary relationship not be required in a bribe case? What he then does, what the learned judge then does, is in the stage 2 analysis, is to work through 13 authorities to consider whether essentially they support that proposition. And if you turn kindly down to page 260, you'll see the heading, the authorities. That's the start of the review. Six cases that have gone through Panama, South Pacific, Shipway and Broadwood, Logicross, all the way to Nelms and Enran. And then if you kindly please turn to 264, having gone through all those 7 authorities, page 264, and it's paragraph 73. So this is the sort of stopping point in his analysis. Bottom of page 264, para 73. All the above cases have emphasised that the duty to give impartial or disinterested advice is the critical factor in bringing the law on bribery and secret commissions into play. So again, the focus is unmistakably on bribery cases and this critical factor of disinterested advice. And then, if I could ask your ladyship in the court to turn through, and I'm not going to pause with the analysis of the next 6 authorities, just to the conclusion at 269, having gone through now the full run of 13 authorities. Para 92, paragraph 92, it's halfway down 269. I conclude from these authorities that the suggested requirement for a fiduciary relationship is no more saying that in the type of case with which we are concerned, the payee of the bribe or secret commission must owe a duty to provide disinterested advice or recommendations or information. And again, without wanting to weary the court will understand that our submission that the type of case which we are concerned was bribery cases. Wood and Pengelly, as your ladyship just indicated, absolutely right, they were fully secret cases. And so Lord Justice David Richards is explicitly addressing here the payee of the bribe or secret commission. That's the context, bribery. And essentially, having gone through 13 cases, the judge is concluding here that the suggested requirement for a fiduciary relationship, which is what Marcus Smith J had identified, was no more than saying that the payee of the bribe must owe a disinterested duty. And one I can understand that, going back to his rationale at 44, the great vice of the bribe, inducing a payee to depart from his duty. This is all you need in a bribe case. The relevant duty, the gateway to the remedy, is the disinterested duty. So essentially you see the 2 stages supporting each other, both the rationale for a less elaborate disinterested duty in bribery cases, supported by the analysis of the authorities. And as I say, it's there at 59 of our skeleton, the ambition and the wrong step in the appeals is to say that this disinterested duty, so unequivocally identified in this bribery context, can be read across to the half-secret case, when it's quite clear that that's not what Lord Justice Richards did in this analysis. What I do, though, want to, well, I'm going to continue to develop this in the 4th point that we make, which we've called, it's para 61 of our skeleton, the relevance of certain cases to the sufficiency of disinterested duty in half-secret cases. There's a very, and actually all I need to do to save time is look at an observation back in Wood in relation, no, sorry, an observation in Wood, yes it is in Wood, in relation to Firstrand. That's the shortcut way to do it. So if we could go back in Wood to paragraph 82. We looked at paragraph 80, and I'd shown the court the third and fourth line that Firstrand is also illuminating on the issue of the necessity for a fiduciary relationship. And I want to get, what's illuminating about it? Well, one turns down to 82. Well, Justice Richards, what is interesting for the purposes of the first issue, the precondition issue, is what Tucky said at 38. Obviously, if there's been no disclosure, the agent would have received a secret commission. That's a blatant breach of his fiduciary duty. But additionally, the payment or receipt of a secret commission is considered to be a form of bribe and is treated in the authorities as a special category of fraud in which it's unnecessary to prove motive, inducement, or loss. The principal has alternative remedies against the briber and the agent, money hadn't received, for damages for fraud in reference to the Matheson case. So, respectfully, that is a crux, piece of learning that is alighted upon by Justice David Richards. Because not only is non-disclosure of a commission a breach of fiduciary duty, it's additionally a special category of fraud. And so then when he comes to 83, as I read that past paragraph, Tucky is distinguishing between the receipt of a bribe as a breach of fiduciary duty and the payment and receipt, this time, of a bribe or secret commission as an actionable wrong in its own right. We think that's very important. What David Richards alights on is the existence of alternative causes of action. Receipt of a bribe as breach of fiduciary duty, but payment and receipt of a bribe as an actionable wrong. So you've got two alternative causes of action. Breach of fiduciary duty by the recipient, which might have accessory liability, bribe at common law and equity, which is an actionable wrong in its own right. And so really that was the answer to Marcus Smith, Miss Justice Marcus Smith's concern. There must be a breach of fiduciary duty as a necessary precondition. That's what the judge had said in Pengelly. But no, says Lord Justice David Richards, not if there is a freestanding, actionable wrong of bribery, which is quite separate from a fiduciary duty. We say that is critical to understanding the different tests in these half-secret cases. I'm not going to go through Conway and Ease and Medstead on this point. I don't think I need to. I will briefly, before finally concluding on this point that I'm on the sort of cusp of concluding, this actionable wrong point, stop off at our point 5, which you'll have seen where we say it's para 69 of our skeleton. Disinterested duty and fiduciary duty not synonymous. You didn't hear quite that adjective used by Mr. Weir in his oral submissions, but it was a claim made at 112 of their skeleton that essentially the terms disinterested duty and fiduciary duty are synonymous ones.
You described it as a subspecies.
Yes, today we've heard it as that. Can I just show, though, how clear it is that Lord Justice David Richards didn't consider that the terms were synonymous in the manner of mention. And I think it might just help to go, and this is the only example I'm going to go to of the cases which were analysed. If one goes back to paragraph 63 at page 262, 262 para 63. And I just that's the context that in what is called a striking authority of Shipway and Broadwood. And I'm not going to go through the case. I think that's familiar to the court. It's the buyer's agreement to buy the 2 horses and the veterinary surgeon who is supposed to be passing them the sound and giving a certificate, but he's getting a fee from this seller. But what if you then go over the page to the Shipway and Broadwood case, which is looked at 63, 64, 65. If you then go to 66, you see the problem. Although Lord Justices Chitty and Collins, but not Lord Justice A.L. Smith, referred to Pinkett as the defendant's agent, he was a professional person engaged by the defendant to give his opinion. It's that duty to give a disinterested opinion that made the secret commission unlawful. It was the necessary incident of his contractual engagement. I'm not sure in what legal sense Pinkett could be described as the defendant's agent. And then he looks at a parallel case of a barrister instructed to advise the client on the legality of a contract. The other intended party knows the advice has been taken and offers to pay the barrister a sum if the contract is made. I should have thought there could be no doubt this would engage the rules and remedies as regards bribes and secret commission. The barrister clearly owes a duty to give his disinterested advice, but a barrister would not normally be considered his or her client's agent or as being in a fiduciary relationship with the client. So that really goes to the heart, we respectfully submit, of the problem identified by Lord Justice David Richards of insisting on fiduciary duties, fiduciary relationships in the bribery context. There's no doubt that in these sorts of scenarios, Mr. Pinkett, the veterinary surgeon, the barrister, that there's a danger of the duty they owe being suborned by a payment that you wouldn't normally consider them to be in a fiduciary relationship. So that's the classic, potentially non-fiduciary relationship that illustrates the risk of demanding a fiduciary relationship. But it's plain in giving that example that Lord Justice Richards acknowledges there are distinctions. I mean, he talked about the fiduciary duty being more elaborate. He talks about the disinterested duty being much simpler. It is quite clear from the effort and energy expended in this judgment on looking at how disinterested duty is enough in bribery that the whole starting point of the Lord Justice is there is a difference. Fiduciary duties are more elaborate. The disinterested duty is much simpler. And so that then brings me, if I might finally, to really the key point, which is point 6 of the skeleton. There are why is a fiduciary relationship required in half-secret cases? And as we've indicated there, really there are 2 points. And the first is the evil bribery practice engaging unique issues of policy. It shouldn't be constrained by the precondition of attempting to identify a fiduciary relationship. That's the sort of policy reason identified effectively in the Court of Appeal. But the second key point is, we say, the cause of action. And can I just, again, to make this crystal clear, look at the different explanations of the judges below that gave rise to this appeal. And I can do it quite quickly. It's in the additional authorities, and it's authority number 40, which is the decision in Pengelly in Business Mortgage Finance. So that's page 1273. So it's tab 40 of the additional authorities. I think that's Is it volume 4? So I'm volume 4 hard copy, I'm sorry.
Volume 3 hard copy.
So tab 40, page 1273, Pengelly and Business Mortgage, the first decision of Justice Marcus Smith. And if I could start, please, in fact, at 1295 in the judgment, under the heading Accessory Liability. So we're top of page 1295, paragraph 50, where the conclusion of the judge here is at 50. It's clear from the foregoing that unless there's a breach of fiduciary duty by the fiduciary in receiving the secret commission, there cannot be any liability in the payer. Note that's a reference to the payer of the secret commission or bribe in making it. It would be absurd and clearly not contemplated by the cases. 51, it follows that the liability of a third party is contingent upon there being a breach of fiduciary duty on the part of the fiduciary to whom the secret commission or bribe is made. So that was the very strong conclusion below, wrong, of course, as identified by Lord Justice Richards, that there must be, and his explanation is because otherwise there can't be any liability. Now, the judgment of Mr. Justice Pickering, very briefly, is at 39, and if I can pick up at
39 of what?
Sorry, tab 39, and it's 1224. So tab 39, it's just back one authority
Yeah.
in that bundle. And it's the decision of Mr. James Pickering, KC, sitting as a deputy judge. And if I could pick up, please, at paragraph 112, so that's at 125, sorry, 1256. 1256 is actually, will save time. 1256, halfway down the page, fully under the heading Fully Secret Commissions, para 129. What Mr. Pickering says, as for fully secret commissions, one, the requirements for a fully secret commission are simple, chiming with the much simpler reference of David Richards' appeal, and are neatly summarised in the threefold test of Slade in industry and mortgages. And then that's said. Two, where an agent receives a fully secret commission, the principal is entitled against both agent and the briber by way of money hadn't received, and looks at the Maheson case and others. And then three, in addition, if the relationship between the principal agent can be described as a fiduciary one, acceptance of the fully secret commission will amount to a breach of fiduciary duty. Four, importantly, however, where the commission is fully secret, the establishment of a fiduciary duty is not essential. As stated above, to be entitled to relief, it's sufficient for a claimant to establish the three simple matters identified by Slade. Establishing a fiduciary duty and a breach of that merely provides an alternative route. So, as I said, those were, to give a bit more flesh, the battle lines below and the differing views of Marcus Smith. There must be a fiduciary duty. The liability is contingent on that. Mr. Pickering, no. In a bribe case, that's not essential. Fiduciary duty is an alternative route. And this, then, as I say, we looked at what David Richards said in Wood at 82, what piqued his interest about an additional remedy in Firstrand. If I can now finalise this and finalise the circle, if I may, back to the analysis in Wood at paragraph 93. So this is page 269 of the core authorities. 269 of the core authorities. Paragraph 93. We haven't looked at this in this hearing yet. In his judgment in the Pengelly case, Marcus Smith regarded the existence of a fiduciary relationship as essential to relief against the payer of the bribe or secret commission. And the same submission was made by counsel for the lender. In the absence of fiduciary relationship, there's no legal basis for a cause of action. 94, with respect to Marcus Smith and Mr. Lord, I do not believe it's borne out by the authorities. They make clear that bribery is an actionable wrong in common law as well as in equity, for which the common law remedies as well as equitable remedies are available. The remedies include rescission of the transaction in connection with the bribe is paid. The payer of the bribe, again, the payer, is rightly viewed not as an accessory, but as a primary wrongdoer. And finally, after that primary wrongdoer reference, if I can ask the court to go down to 101. 101. These authorities demonstrate that the common law remedies of money hadn't received and damages are available against a third-party payer of a bribe, and that rescission is available as a right. None of this depends on establishing that the third party is an accessory to a breach of fiduciary duty by the payee. So perhaps I've laboured it, and if I have, apologies. But what I'm trying to identify is the fact that the solution to the difficulty identified by counsel for the lender and Mr. Justice Marcus Smith below, that if you haven't got a fiduciary relationship, there's just no legal basis for a cause of action. That the fiduciary relationship was an essential precondition. The solution was simple. That's wrong, because bribery is an actionable wrong in itself, in common law and in equity. And the remedies are available directly against the bribe. So you don't need an accessory liability at all. You certainly don't need a fiduciary relationship. But That's all in the bribery context. And as we say at para 76 of our skeleton argument, the position in half-secret commission cases is different because there is no bribe. And it's not appropriate to treat such cases as a category of fraud. See Lord Justice Tuckey in Herstanger at 39. They're not fraud cases. So there's no question of an actionable wrong in its own right against the bank in this case. So a breach of fiduciary duty is a critical component of the cause of action against the broker who receives the commission in breach of fiduciary duty, and against the lender payer as an accessory to that breach. And it might help to see, I mean, obviously, essentially, Lord Justice Wood has favoured the Pickering approach below. If I might just, there's one other paragraph that might help the court to see in 39 of the additional authorities, at 1257. Back in the Wood first instance case, so this is the additional authorities, 1257. Here at 130, Mr. Pickering deals with half-secret commissions. At 131, partial disclosure refers to Herstanger, and then look at 4. While, however, the common law remedies may not apply, the payment of a half-secret commission may nevertheless be actionable where it can be shown that a fiduciary relationship existed between the principal and the agent. Where such a fiduciary relationship can be shown, the agent may put the agent into a position.
Well, he's picking that up directly from Herstanger.
Yes, I think that's right.
Because of the way in which Lord Justice Tuckey expressed himself. Because Herstanger was decided at a time before Wood. We now have to decide whether what Lord Justice Richards said in Wood in any way qualifies in terms of the analysis that he has placed. What at the moment is bothering me, and I'd like to know what you say about it, is the fact that the mischief, if you like, is the potential that's been identified by Lord Justice David Richards, is the potential for the agent, in inverted commas, not to act in the best interests of the client, because there is the incentive, if you like, being given to him to pick lender A over lender B because lender A is going to pay him more money. That problem, to try and use very neutral terminology, that problem arises irrespective of whether it's a half-secret case or a fully secret case, doesn't it? The policy consideration that actually makes it wrong not to give full and informed consent to what's going on is because there is an incentive being given to the, in inverted commas, agent not to act in his, in inverted commas, principal's best interests. And now, why doesn't that mean that the policy considerations apply across the board in just as much to a half-secret case as they do to a fully secret case?
Well, a half-secret case is not a fraud case. It's not a bribery case. It doesn't engage the 200 years of authority so carefully looked at by Lord Justice Richards, and it doesn't engage in the same way the policy considerations, the great vice of secrecy.
But there still well, it does and it doesn't, because it is there is still secrecy. There is not full disclosure, and therefore you've got exactly the same consideration, which is basically that the party who's complaining doesn't know the full story, and he doesn't know the full story, and the reason that it's not right that he doesn't know the full story is because the party who is in the relevant relationship with him stands to profit at his expense without his knowing that.
My lady, I think the best answer I can give is respectfully that Lord Justice Tuckey's analysis in Firstrand gets it absolutely right. That outside the very special bribe context, if the secret is out to the extent that secrecy is negated, so that one moves away from the very well-known bribery cases, one is in a different position. There is still a breach of fiduciary duty. The fiduciary, if there is such a fiduciary, has still not done enough. But in those cases, not a fraud case, you don't get the right, the rescission as a right. You are into equitable remedies, which are at the discretion of the court. And that, respectfully, in my view, gets the balance right between the bribe cases and the inadequate but secrecy negated disclosure cases, as analysed by Lord Justice Tuckey. It's the halfway house. It's imperfect, but it's not a fraud. My lady, can I also just, we obviously were interested when we were receiving this supplemental skeleton argument of the appellants to see what they said about this analysis of ours. It's all in the remedies, the bribery actionable wrong. What happens when there isn't that actionable wrong? What are you left with? And can I just take the court's attention to a couple of paragraphs in the appellant skeleton argument,
Yes.
which we were very interested to see, because there's quite a lot of common ground here. And it's page 451 of the core bundle, the appellant skeleton argument, is supplemental skeleton argument. And it's para 19 that I wanted to look at in the first instance. Page 451, core bundle. Paragraph 19. So this is the supplemental skeleton argument, which was came back in relation to our skeletons. And if you see at 19, where secrecy is negated, but informed consent has not been obtained, the agent remains in breach. Correct. Just pausing there. Absolutely. Absolutely accept that. That's straight Firstrand. But the principal loses his direct entitlement against the briber, against the payer. Absolutely accept that. That's quite clear, because if there's no bribery case, there's no direct claim. We're into an accessory claim. And then 3, the principal retains an indirect equitable cause of action against the payer as an accessory, for which rescission is a discretionary remedy rather than one arising as of right. Well, we accept that in part. There is a potential indirect equitable cause of action. And yes, that equitable remedy is discretion. But whether or not the principal has that cause of action depends on a breach of duty. And actually, you'll see they've cited paras 34 and 47 of Firstrand, in both of which Lord Justice Tuckey refers to a breach of a fiduciary duty. If I can also put under the spotlight paragraph, well, let me just, sorry, I probably can't just ignore 23, 24 and 25. If you just look briefly at 23, 24 and 25, this is an analysis of the Maheson case, the Lord Diplock bribery case, where it's analysed that equitable remedies not confined to cases of fiduciary relationships, no suggestion in Lord Diplock's judgment payer was liable only as an accessory for another's breach, that a breach of fiduciary duty was necessary. All absolutely right, because it was a bribery case giving rise to both common law and equitable remedies. Maheson, Lord Diplock, as quoted in Wood, the giving of the bribe was treated as an equity, as a constructive fraud. Again, we agree that. That's why one sees both common law and equitable remedies arising out of breach cases. And then at 24, last line, this equitable right was additional to his right to recover the bribe. 25, and this is the paragraph I want to focus on. In the light of the context is set out above, it's clear that David Richards' concluding statement that none of this depends on establishing that the third party is necessary to a breach of fiduciary duty by the payee was to the effect that in a secret commission claim against the payer, neither common law nor equity require it to be established that the broker owed a fiduciary duty. Well, that's certainly right in the secret commission bribery case. None of it depends on a fiduciary duty. There's a freestanding actionable wrong. But that was the reasoning at 101, it was giving the answer to Mr. Justice Marcus Smith's concern, which was summarised 7 paragraphs earlier. What do we do? There's no cause of action. Yes, there is. There's the primary liability. But perhaps, sorry, 25, I said that was the one I was really going to focus on. There's no problem with any of that. 26, I'm sorry, is actually what I wanted to focus on, which is, in a nutshell, the appellant's case, the test for whether duties are owed is the same in common law and equity. 26, there's no cause of action at common law against agent or third-party payer where the commission is half secret. Absolutely right. No cause of action against the payer where the commission, there's no bribe case.
Well, he's not procuring a bribe.
Yeah. The cause of action is in equity. The liability of the payer is indirect as an accessory to the agent's breach of duty, but the relevant duty remains the disinterested duty. And that, of course, is where we completely disagree. That is wrong, and it just doesn't make sense, in fact. And it's a point that my Lord Justice Edis was grappling with. What does it mean to be an accessory to the disinterested duty? The disinterested duty is, of course, shorthand for what Lord Justice Richard described as a duty to provide information, advice, recommendation on an impartial or disinterested basis. That's 48. And what the disinterested duty is the content of the relevant duty for the purposes of bribery cases. It's the content of the duty that engages the law of bribery. It's not on its own some recognised freestanding equitable duty. It's the gateway to the bribe remedy. It's the content of the duty that the bribe may induce the payee to depart from. But it's not in itself a creature known to law. And one can't be an accessory to a disinterested duty. One can be an accessory to a breach of trust, or a fiduciary obligation, or a tort, or the other categories that were looked at this morning, but not a disinterested duty. One can't be an accessory to the content of a duty, which is the gateway to bribery remedy. And I don't actually think, I was proposing to show the court the authorities of Twin Sectra. I expect that's extremely well known, and the expert tooling case of His Honour Judge Saffman. I don't actually think I need to do that. And they're both completely standard applications of looking at the requirement for dishonesty, of course, TAN and Twin Sectra, but also repeatedly referring to a breach of trust, breach of fiduciary duty. And that's why the questioning has been so important in relation to, well, what is this accessory liability to? That's why this is so novel, but also, I respectfully submit, so unreasoned. We know precisely what the disinterested duty is. The content of the duty that engages the law of bribery is analysed by Lord Justice Tuckey. It's not a freestanding new equitable doctrine. And it's not something to which one can be an accessory to. And as I say, there are all sorts of arguments deployed by the appellants as to the fact that similar duties are analysed in the disinterested duty and fiduciary duty context. And then it's said, well, the same test must apply. Well, that's just wrong with respect. You're looking at two different causes of action, a freestanding bribery cause of action in a bribery case where the payer is the primary wrongdoer. They need to look for fiduciary relationships, and the different context outside the bribe case where one is really back to Marcus Smith's territory. Where's the cause of action? Well, it's a fiduciary duty. What Lord Justice David Richards clearly didn't do was to seek to rewrite the test of a fiduciary relationship and fiduciary duties in Wood. That's not what he embarks upon at all. What he's doing is identifying the much simpler, paragraph 50, much simpler disinterested duty, which is all that is necessary in a bribe case. Less elaborate, much simpler. He simply didn't engage and didn't purport to engage in his analysis in relation to the idea that his disinterested duty, the content of the duty that engages bribery, is enough in half-secret cases. And yet he'd quoted Firstrand, Medstead, McWilliam. He'd made references 4 times to the requirement for a fiduciary relationship in those contexts. Having embarked upon the detailed analysis that he did, one wonders to oneself, well, if that's what he'd intended, would it not have been easy enough to state it? But it's perfectly obvious in my respect for submission what actually was concerning Lord Justice David Richards and why he did the analysis that he did. That very much almost brings me to the final. The only thing, of course, that I need just to reiterate is our final criticism of those paragraphs is the dishonesty requirement, because they talk about an indirect equitable cause of action against the payer as an accessory in a half-secret case. But that's not enough, and they accept that. There must be dishonesty in accordance with the well-settled authorities of TAN, Twin Sectra, recently expert tooling, and the more recent case referred to by my lordship. So that brings me to the conclusion on that issue, whether the disinterested duty is sufficient in half-secret cases, and to my final issue in relation to whether the brokers owed either a fiduciary duty or a disinterested duty. And as I say, that really wraps up both the second and third issues considered by Mr. Weir yesterday. And I can, in my skeleton argument, again, just so that I can anchor myself in that, I'm now at paragraph 81. And as I say, the issue arises in Johnson, 1A and B, and in Wrench. And I deal with it in those contexts, both the fiduciary and the disinterested duty point. We do make one initial and preliminary observation in Wrench. You'll see at 83 that the fiduciary duty is not pleaded. And of course, we accept the obvious point that the CPR 16.4 para 1A only requires a concise statement of facts, and we concede obviously that pleading law is optional. Paragraph Practice Direction 16 para 12.21. That's not the point that we're making. The problem is that because a fiduciary duty is simply not mentioned in the pleading in Wrench, the facts on which the claimant relies, which are of course mandatory, are not mentioned either. There are no pleaded facts. All that's pleaded, I mean, I should take, I can't shortcut this, I need to take the court briefly to it. It's core bundle, para 28. I'm sorry, paragraph 20, sorry, tab 28, I'm so sorry. Tab 28. It's just a short point, I don't want to take too much time on it, but at 342 of the core bundle. And I should have said that I'm beginning this analysis with the fiduciary duty analysis, as indicated in the skeleton. I'm starting with the idea of a fiduciary duty, and this first point that there never was any pleading of a fiduciary duty in Wrench, and you see that at paragraphs 11 and 12, top of page 342, the claimant's case is the defendant was under duty to provide information or advice or recommendation on a disinterested or impartial basis, and then paragraph 12, they set out a reliance on would. And there is no reference to any sort of fiduciary duty. And if you then kindly can go to the judgment of Deputy District Judge Harrop at page 316. 316, and it is paragraph 26. It's about quarter of the way down that page, 316. So this is the judgment at first instance, 26. Says, I am therefore satisfied the claimant's relationship with the broker was such as to engage the law of bribes and secret commission. So he's applying would there as pleaded, although obviously that was overturned on appeal because of the misreading para 120 of Wood. That's the first instance. And then if you see His Honour Judge Worcester on appeal at 269, please, of the bundle. Paragraph 30. So this is 269, paragraph 30. This is the decision of His Honour Judge Worcester. Para 30. The first point is a relatively simple one. This was not a fully secret commission case. It was a half-secret commission case, and for the claims to succeed, Mr. Wrench must establish he was owed a fiduciary duty. Having found that the commission payments were fully secret, the judge didn't deal with the issue of whether or not Mr. Wrench was owed a fiduciary duty by the brokers, therefore no consideration of whether or not there was a basis for rescission for breach of fiduciary duty. So that's just fiduciary duty was never considered by the judge. And I should also ask you to look, please, at paragraph 38. Paragraph 38, which is where His Honour Judge Worcester is dealing with the respondent's notice. Fourth and fifth grounds can be considered together. By ground 4, it's contended the judge's findings of the judgment amounted to a finding the dealers did owe fiduciary duties. Jumping 2 lines, it's plain from a reading of the judgment that the judge didn't consider whether or not the dealers were fiduciaries. There's nothing in his reasoning which would form a basis for such a finding. Then the selling cars point he makes, which you've seen, hard to see how they could offer single-minded loyalty. Last 2 lines, I can't accept the arguments put forward under ground 4 and 5. Sorry, again, I don't want to take this too long, but the simple point is a fiduciary duty wasn't pleaded. No facts in support of a fiduciary duty were pleaded. Deputy District Judge Harrop doesn't embark upon any analysis of fiduciary duty. And His Honour Judge Worcester, his start point and his end point was, well, the fiduciary duty question wasn't considered at all. And on that point, he clearly is right. Without dwelling any more on that point, if I can come then to the fiduciary duty test and whether it applies in this case, and that is from paragraph 84 of our skeleton. And look, obviously, there is almost complete common ground between myself and Mr. Weir on this, and the court would expect nothing different. We've set out at 84 the familiar passage of Lord Justice Millett and Mothew. We've set out what we consider as a helpful short passage from Lady Arden in the CIFF case from Miss Justice Finn in Grimaldi, which puts it, in our respect, for submission about as well as one can put it. A person will be in a fiduciary relationship with another when and insofar as that person has undertaken, we set this out in paragraph 85 of the skeleton, undertaken to perform a function or assumed such a responsibility to another as would thereby reasonably entitle that other to expect that he or she will act in the other's interests to the exclusion of his or her own. And Lady Arden then noted in the next paragraph, again, I'm just looking at my skeleton at the moment, that this formulation of the test introduces the additional concept of reasonable expectation of abnegation of self-interest. And that respectfully captures the law quite properly. The court will have seen in the supplemental skeleton argument a raft of other cases referred to by the appellants, and some of them the court was referred to yesterday, the decision of Justice Sales, as he then was in F&C Alternatives, who used the language of fiduciary duties are imposed as a reaction to particular circumstances or responsibility assumed. Again, obviously, we agree with that formulation. Or the explanation of Lord Justice Mummery in Pescia and of Mr. Justice Newey in Vivendi of the undertaking or assumption of responsibility, not in a tortious sense. So there's nothing between my learned friend and I on this. We accept fiduciary duties can be imposed, but imposed as a reaction to an undertaking or assumption of responsibility or a particular function. And so really the starting point is to determine what responsibilities have been assumed, what functions have been undertaken, because once one's analysed the functions and responsibilities assumed and undertaken, that informs whether there is a reasonable expectation of an abnegation of self-interest, to quote Lady Arden. The only other point I wanted to make on the law is the short point that, as this court has repeatedly observed, it is exceptional for fiduciary duties to arise other than in certain settled categories of relationship, outside the paradigms of the trustee, partners, company directors. We don't need to look at Snell, but there was one part of the Lord Justice Leggett decision in Kent that it's useful to see, and that is at supplemental authorities, page 337. Supplemental authorities, tab 8, page 337. And I asked the court just to look at the opening words of paragraph 157, where Lord Justice Leggett says, in considering this submission, I bear in mind that it is exceptional for fiduciary duties to arise other than settled categories of relationship. And then he looked at those settled categories. 158 you were referred to by my Mr. Weir yesterday. At 159 there's also a passage that I know Mr. Wilson is interested in. 159, fiduciary duties typically arise where one person undertakes and is entrusted with authority to manage the property of others. Such duties may also arise where the responsibility undertaken doesn't directly involve making decisions, but involves the giving advice in a context where the advisor has a substantial degree of power over the other party's decision-making. See Lionel Smith. That's a reference that comes up in another context. So my purpose of referring to that is really just the exceptional part of ad hoc fiduciary duties. So I come then to the application of the test. And the essence of the appellant's argument, without really making a distinction between fiduciary duty or disinterested duty, is that it proceeds from, para 102 of their skeleton, and is implied from, that's paragraphs 117 and 118, the function the broker was exercising. So that really is the essence of the case here. The functions of the broker give the answer as to these duties being owed. Can I just start with the definition of credit broking? And the court will find that at additional authorities, tab 53, page 1522. So 1522, tab 53. No, 1522, tab 53. So what we've produced here is Article 36A credit broking definition under the FSMA 2000 Regulated Activities Order. And you'll see both parties sidebar. I'm so sorry, my lady.
Sorry.
Additional authorities.
I'm trying to find tab 53.
Bundle through, really.
Yes.
That's near the end.
Every other
I don't have a breakdown.
I put it down somewhere. Oh, there it is. Sorry. Tab 53.
Tab 53,
yeah.
page
Yeah.
1522.
Yep.
And there
This
we
is
have
the regulations.
Yes, and credit broking here defined as affecting an introduction of an individual or relevant recipient of credit who wishes to enter into a credit agreement to a person, that's the bank in this case, with a view to the bank entering into, by way of business as lender, a regulated agreement. So that is the definition, and in each case, certainly First Lane Motors, TT Prestige in the Wrench case, Trade Centre Wales, that's what they were doing. They were effecting an introduction of the individuals who wished to enter into credit agreements. The introduction was effected to the bank, and it was with a view to the bank entering into by way of business as lender a regulated credit agreement. And that is all straightforward. And that primary introductory role is acknowledged by the appellants, 13 of their skeleton. And that is the starting point in this case, respectively. And there's nothing exceptional about an introductory role in that sense, using the word exceptional of Law Justice Leg. Nothing that would reasonably entitle this customer to expect an abnegation of self-interest. Well, one needs to then look, the next stepping stone in the appellant's case is looking at the broker functions described by Imogen Shaw, the Hopcraft witness. And no doubt Mr. Wilson will be looking at Miss Shaw's evidence, which isn't my evidence, but it's probably the easiest way to look at this is in the appellant's skeleton arguments and how they analyse the functions performed by the broker. In paragraph 16 of their skeleton arguments, it's in the core bundle, isn't it? So the appellant's skeleton argument, the original skeleton argument in the core bundle at tab 1.
Which tab?
Tab 1, page 9.
Tab 1, page 9. Thank you. And I'm looking at paragraph 16. So this is the assessment of the broker roles. And this is the appellants looking at what Imogen Shaw says about the description of the broker. And just to take it in turn, we start with 16A. The customer requires finance. A representative from the broker will go through an information gathering process with them. This includes discussions regarding what deposit the customer wants to put on the vehicle, what amount the customer can pay, how long the customer wants to finance the vehicle. So that's the first, essentially, information gathering role that is described by Ms. Shaw. In fact, in paragraph 9 of her statement summarised here, with which we certainly agree. Then we have 16B, that the broker uploads the information obtained from the customer in the form of a proposal to an electronic platform that connects dealers, lenders, and finance brokers. So certainly that is the second role performed. In fact, Ms. Shaw referred to a platform called Code Weavers in that particular case. No doubt there are different types of platform. But that, we say again, is all entirely consistent with an introducing function, connecting dealers, lenders, and finance brokers. And then we have C, the reference to the number of lenders that work will depend on the size of the dealership, and that is a summary of Ms. Shaw's evidence of paragraph 10. And then finally, D, if a proposal is sent to the broker via the platform, the broker is required to assess the affordability and ensure the customer understands the key terms of the credit agreement. The broker will liaise with the customer as to whether any conditions are acceptable. So that is the overview of the sales process. And respectfully, we submit that is an essentially administrative process of gathering and uploading information, which concludes with a proposal sent by the lender to the broker on the platform, and then the broker liaises with the customer in relation to the lender's conditions. Nothing we respectfully submit about that explains why these brokers should owe a duty of single-minded loyalty, or why there should be a reasonable expectation of an abnegation of self-interest. One thing I should pause on, though, is the reference here to the requirement of the broker assessing affordability. And can I just show your ladyship that, in fact, in our cases, the lender, Firstrand Bank, was assessing affordability. And just two documents which show that, please. It's at tab 5 of the supplemental bundle in Wrench. Tab 5, supplemental bundle in Wrench, page 35. Page 35. So supplemental bundle, Wrench, page 35. A smudged document. I apologise. I've tried to get a better document. But it's in a black, not easy to read heading at the top, the pre-contractual explanations for a hire purchase agreement. It's a Motonovo document. One sees that 4 lines down. You've been accepted by Motonovo. and then just above the signature at the bottom, you'll see it says, in assessing your application for credit, we will assess your ability to pay the repayments due. So it's Firstrand Bank here doing the assessment of the repayment ability, and the very same documents in the same terms.
Doesn't mean that the broker wouldn't do it as well.
That's I accept that, my lady. Accept it. Can I then come to the focus by the appellants on the suitability documents? And of course, you will have read what they say at paragraph 17 of their skeleton. We probably don't need to, but that's the focus of so much of the argument now. If I could then go back to that document at tab 11 of the Johnson one. And again, you've seen this a couple of times now. Page 37 of the supplemental bundle in Johnson. And at 38, you have seen both the dealer commission disclosure halfway down, and you've also seen, obviously, the panel of lenders redacted. Firstrand Bank appearing over the page at 39. Just pausing here at the moment. Obviously, that is a document that one might think is important for both parties' cases, both in relation to disclosure of commission and the panel. And we've looked at this quite carefully. It was in the trial bundle. It was in the Johnson trial bundle. It was at tab 6 in the claimant's list of standard disclosure. Going straight back to Lady Justice Andrews' observation. It didn't come from us. It was the claimant's list of standard disclosure, tab 6. It was at page 60 of the trial bundle. So it's Mr. Johnson's document. But for reasons which are not clear, are wholly unclear, no reliance was placed upon this document at the trial by either party. Now, the first step, as your ladyship knows, is we've already looked at the statement of Richard Irving at the bank, saying, I believe the dealer would have given the dealer disclosure document, we haven't been able to find it. That was the first stage. And I should make it absolutely clear, in that trial bundle in Johnson, tab 7 was the defendant's list of standard disclosure, the banks, and it wasn't there. This document wasn't there. So that obviously fits with Mr. Irving's evidence. Well, I haven't got a copy of it. But what then happens next is the transcript of the oral hearing is at tab 19. And if I could ask the court to start at 77. And so we're now looking at tab 19, page 77. This is the transcript of the hearing on the 29th of November 2022. And Ian MacDonald of counsel for the bank is cross-examining Mr. Johnson. And if you see it 6 lines down, question. So the barrister asks, what Mr. Irving says at paragraph 10 is that before applying for finance, believe the dealer would have given the dealer disclosure document. And then what you see is, sorry, Mr. Johnson, I want to set the scene. Answer, yes. Have you not got a copy of the documents? Answer, not anymore, I do not. No. Answer, I do not have them anymore. A question, so would it be fair to say you cannot say Mr. Irving is wrong? Now, at this point, Mr. Butters, counsel for Mr. Johnson, says it's a completely unfair question. This is a document that has not been produced, if it exists at all. And my client is being asked in another witness who is yet to give evidence. Wrong to say that a document that no one has seen was provided to my client. So Mr. Butters doesn't like this question about a document that nobody's seen. Now, the judge allows the question to carry on. And if you turn to the bottom of 78, Mr. MacDonald proceeds again, about 3/4 of the way down. I think my learned friend would have been entitled to object if I'd not put it as part of my case. Let us go back, Mr. Johnson. I think you've agreed with me. You do not have your own copy of these documents. from the back of what I said, it'd be fair to say you cannot say whether Mr. Irving is right or wrong. Okay, yes, okay. So you're agreeing you cannot say? Yes. And sorry.
Well, that was a fair request.
Yes. Then the
First
final
one wasn't.
the final bit at 79, at about 3/4 of the way down on page 79, is it also right you cannot say whether or not as to whether the documentation included the document Mr. Irving describes as the dealer disclosure document? Yes, as I no longer have any of it myself. So as I say, this is all frankly pretty curious, because Mr. Irving says he hasn't got the document, but it would have been given. Mr. Butters objects to cross-examination on this document because it's not been produced if it exists at all.
Well, he's not being cross-examined on the suitability document. He's being cross-examined on the dealer disclosure document.
This is the same document. This is the dealer disclosure document.
Well, no, it's not. The dealer disclosure document is this hypothetical document that the bank's witnesses say that they believe would have been given by the dealers to the person concerned. But the suitability document isn't necessarily the same document.
My lady, I've taken careful instructions on this, and certainly our understanding is it's exactly the same document.
How do your clients know? Your clients can't know. They're a bank. They don't know what goes on inside the dealership.
Well, all I can say, and your ladyship is obviously right to make that observation, but this is the document. It's the only document where a dealer discloses commission. Dealer disclosure document. That is what we understand this suitability document to be.
But that's not its purpose. You see, the only reason I'm taking issue with you on this is because, as I understood it, and the way that you opened it, what was envisaged perfectly properly by the bank is that there is going to be some kind of document, the purpose of which is to disclose the existence of the commission, whether it be in boldface or somewhere else. And that's its function. Whereas this document plainly doesn't have that function. Its function is completely different, but there is a disclosure in the course of it. Its function is to actually say, look, these are the services we're going to provide for you. These are the lenders that who are on our panel. This is what we undertake we're going to do as your credit broker. And then in the course of that, of course, there's a mention of the commission.
Well, really, I obviously understand that observation, and your ladyship's absolutely right in has seen our prescription that you must disclose commission without prescribing precisely how they do it. It is left to the dealer to do it. Our understanding is this is precisely
the way that they were
the
doing
Trade Centre Wales does it.
Yeah.
Now, whether or not one thinks that is adequate, that is how this dealer has interpreted its obligation. And that's certainly how when the lender says DDD, dealer disclosure document, in that slightly way that Mr. Irving and Mr. Scott would do, it's this document they're talking about. I mean,
it's very strange that if that's the case, I mean, one finds it very strange that there is a document which is actually in the trial bundle that everybody is ignoring, which is supposed to be the document that is the subject. I mean, I would have thought that counsel, Mr. MacDonald, would have shown it to Mr. Johnson and said, weren't you given this?
We do not understand what happened here. It was page 60 of a 260-page trial bundle. But to be absolutely clear, Mr. Butter objects to any cross-examination on a document disclosing commission. There's no cross-examination on Mr. Irving of this suitability document. And in closing submissions, it was submitted to the judge that no dealer disclosure document was provided. That was the submission. And there is no reference by District Judge Sandercock to either to this suitability document, page 60 of the bundle. And that's why, and it's something Mr. Popplewell will develop, that was what caused His Honour Judge Jarman to stop paras 35 to 37 of his judgment. Because, what's the judge found in relation to dealer disclosure? There's an unresolved question.
Yeah.
So anyway, it is curious, my lady. There's no doubt about it. But I've given it some airtime because very considerable prominence is now given to this document, to which no prominence, no reliance was made at the trial below.
Well, before we rise, in a nutshell, what are you suggesting we do about it? I mean, I get the complaint. It wasn't dealt with at first instance. We've got it now. Are you telling us that we should ignore it because that's going to cause you problems?
No, I don't say that. What the next steps in my submission were to, first of all, to show you what the evidence of Mr. Johnson was in relation to the nature of what he was offered, both in terms of car and finance. And then having done that, I was and what happened at trial in relation to the finance offers. And then I was going to take you very carefully through this document to show you what functions actually, when you carefully look at parts of this document to which you weren't taken by Mr. Weir, this discloses in terms of functions. And I will be submitting that by this document, all that the broker says is it will find a consumer finance option. It says nothing about you'll get the best lender. There's nothing comparative. There's no element of the document that does that at all. They find the consumer finance product, which is hire purchase, surprise, surprise, as Mr. Johnson's got £100 by way of deposit and the car is £6,499. So the consumer finance product is hire purchase, one lender and one lender only is provided. But there's nothing about this document quite different to McWilliams. You had the, I forget her name, was she Mrs. Wilson of Norton, who says we'll give the most competitive interest rate. 37, I think, of McWilliams. There's nothing of that ilk in this case. There's no comparative statement will get you the best. Right. This is just a broker with a panel of lenders, so it can service as wide a base of customers as possible. And I'm going to develop that point tomorrow as well.
Now, how are we doing generally on time? How much longer do you think you've got, Mr. Hardwick? You seem to be making pretty good progress.
Making pretty good progress, but I have got another hour and 20 minutes.
Mr. Wilson, are we going?
I'll talk to Mr. Hardwick outside of court. I was to reprimand him about that. I was rather hoping to start by about 11:30, but we'll have a discussion and see if we can work it out.
Well, all I want to know is whether or not we ought to, at a prudent, start at 10.
I would be very in favour, if I might be so bold.
You all right with that?
I'm happy with that.
Well, subject to the court staff being able to accommodate us again as they have today, I'm going to say 10 o'clock tomorrow to be on the safe side. Right. Well, thank you very much. And once again, I'm very grateful to everybody for sitting sort of Maxwell hours, slightly truncated Maxwell hours today. But I think we have managed to get through quite a lot. So 10 o'clock tomorrow. Thank you.
Where I can change.
How about if you guys have an hour and a half? Then you can. Yeah.
Let's have a look. Actually, when did we restart that session? No, but that last session. Oh, I think that was actually, I started.